Wriggles?
Yes.
We are.
Yeah, sure.
Yeah. Yeah. Yeah, they're great.
Yeah.
Right.
Yeah, buttons.
Yeah.
Accreditation program.
Yeah, and you're right. It's happening fast. It's not really.
It's
Yeah.
Yeah.
Right. Yeah, yeah. And so we're trying to come up with something for this program. What about contracts?
Well, that's another opinion.
Yeah. Yeah, yeah. Well, and I don't know that like.
So kudos to you.
Thank you. Yes, they're looking at some feedback very early, like keep reminding people who come in who are not as involved with it as you are.
They're also very tech savvy too. We kind of learn from each other sometimes.
Yeah.
And they're doing some good stuff.
Yeah, I've heard they have some.
Yeah.
Oh, he's like really good. Yeah, I don't know the other side, the danger of.
Ben would probably.
Yeah, yeah. Great.
Anyway, well,
Thank you. Yeah, no, that's great. Certainly thank you that we're. Oh, okay. Okay. Yeah.
But we're prepared to address all questions.
Yeah. Yeah.
Great. Anyway.
Thank
Thank
you.
you.
Yeah, he sounds like I was. In the morning.
Hello. Yes, is this Charlie?
Oh, you very.
Hi.
Yeah.
Nope, that's, let me just verify.
Great, yeah.
You get pre-registered, you said, right? Yes, yep, yep, I see it, you're number 7. So we'll call you when your concern has come and you'll be moved into the panel so that you will be seen and heard on here. 3 minutes. You're welcome.
Really? Yeah.
One problem. Yeah.
Did that work for you?
It's gonna share with dogs. I don't think they're.
Do you want to look in? Let's look at. Oh, you want to help them?
I'll watch it set up.
Yeah. But this location.
You know. They're better able to answer.
That's good.
Yeah. Our whole team is going to be sitting over there. Wayne was just there a moment ago. Wayne. Wayne wants. Mhm.
The most problematic.
I said, thank you. Got it.
I had from those automatic things.
Crazy.
I'm not sure. Yeah, I know. We're all intimidated by mic talks that are on. And what's really deceiving is push to talk, but it's on. So. All right. It's streaming right now, but you can also Zoom if you like. It's private Massachusetts Department of Utilities.
Testing, does that work? Testing?
Greg, can you hear us?
Yes, can you hear me?
Yes, perfect, thank you.
Got it.
Regals? Regals? So Greg, can we do that one more time, please? I want to make sure your video appears when you're talking.
All right, how's this?
Good morning, Greg.
Perfect.
Good morning.
Good to see you.
Good to see you. I'm sorry you can't be there in person.
While we have while the people are talking, there's after that.
Jonathan? Let me try your mic.
Yes, can you hear me?
Yes, perfect.
Excellent.
Okay. Those are the two board members who will be remote for today's hearing. We'll introduce them in a little while, officially. So, Alan, how are we doing?
We're all ready.
All right, let's get started.
Everybody
Thank you,
ready?
Alan, for rushing here. We are lucky to have today the best stenographer in Massachusetts. So thank you for joining us. Good morning, everyone. My name is Rebecca Tepper, and I am the Secretary of Energy and Environmental Affairs. This is a hybrid meeting of the Energy Facility Siting Board taking place here at 100 Cambridge Street in Boston and on Zoom. This hybrid meeting format is new for the Siting Board, and it's intended to allow everyone to see and hear all speakers, whether here or on Zoom. With me today are the other members of the Siting Board, and I thought we could go have everybody introduce themselves. So why don't we start?
Joseph Bonfilio.
Joe, could you move your mic a little bit closer?
Sure. Joseph Bonfilio.
Good morning, Elizabeth Mahoney. I'm the Commissioner of the Department of Energy Resources.
I'm Andy Green, Director of the Siting Board.
Jamie Van Ostrin, Chair of the Massachusetts Department of Public Utilities.
Good morning, Stacy Rubin, Commissioner at the Department of Public Utilities.
Bonnie Heibel, Commissioner, Mass DEP.
Greg? Oh, can't hear you.
Greg, you're muted.
Hi, Greg Watson, public member representing the energy sector.
Jonathan?
I'm Jonathan Pasco. I am the General Counsel for the Executive Office of Economic Development and the designee of the Secretary of Economic Development, Yvonne Howe.
Okay, great, thank you. So this meeting today concerns EFSB 20-01, DPU 20-56, and 20-57. Petitions by Park City Wind to construct and operate offshore and onshore cables and a new substation that would connect to a proposed 800 megawatt wind farm 20 miles south of Martha's Vineyard to the existing Eversource West Barnstable substation, and from there to the New England power grid. The purpose of today's meeting is to listen to comments, deliberate, and vote on whether to approve with conditions, or reject the tentative decision issued by the Siting Board staff on November 22nd. The Siting Board provided notice of today's meeting in the following entities: the service list for this proceeding, the Town of Barnstable's offices and officials, state legislative members of the Barnstable area, community-based organizations in the Barnstable area, and by mail to residents and property owners in the vicinity of the proposed transmission line route and substation locations. The notice was also posted on the Siting Board's website and the company website. In addition, notice of this board meeting was provided under the Massachusetts Open Meeting Law. At the outset, I would like to note that the tentative decision and today's meeting is not about whether the Siting Board should approve the Park City Wind offshore wind farm. Because the wind farm will be located in federal waters, that decision will be made by the Federal Bureau of Ocean Energy Management, not the Commonwealth. The Siting Board does have jurisdiction over 23 miles of the proposed offshore cable in state waters and the onshore underground cables and transmission facilities that would deliver the Park City Wind's power to the West Barnstable substation. Before we begin the substance, I do have some important information about how we'll be conducting this meeting. The Siting Board is conducting this meeting both in person and remotely using Zoom. This meeting is being recorded and will be available on the Siting Board's YouTube channel. For our remote attendees, if you are having difficulty with Zoom, please call or text 857-200-0065. That's 857-200-0065 for assistance at any time. A couple of other procedures we will be following. All board members will have to be audible to each other and the audience. And if there are significant technical difficulties, we'll stop the meeting to allow the problem to be resolved. A stenographer is present today to transcribe everything said to make an official record of the meeting. Everyone should speak slowly and clearly and allow the prior speakers to finish before you begin speaking. These procedures allow us to have an accurate transcript. The sequence of today's board meeting is as follows. We will listen to comments from the public officials. Then the Siting Board's presiding officer will make a presentation, followed by comments from Park City Wind and the parties in the proceeding. And finally, we will listen to public commenters. The board will then begin its deliberation on the tentative decision, consider possible amendments to the tentative decision, and finally vote on the tentative decision. We will take a break at 11 o'clock, a 15-minute break around 12:30, and we intend to wrap up at 2 o'clock today. I don't anticipate a formal lunch break, but we have provided some light snacks for everyone during the afternoon breaks, which will be set up on the side tables. So please help yourself. If you would like to present comments to the Siting Board today, you should have pre-registered to do so as described in the notice. If you have not pre-registered, we will do our best to accommodate you within the time available. From the written comments we have received, the board understands that many wish to express concern about the project and that these same concerns are shared by residents in the community. We have received over 400 comments on the tentative decision, many quite similar, but all appreciated. Public commenters are reminded to keep comments to 3 minutes. We will gently remind speakers when it's time to wrap up, about 30 seconds before the 3-minute mark and then at 3 minutes. Public officials who comment have additional time as needed. In the interest of hearing all viewpoints today, if your viewpoint has already been addressed by prior commenters, please indicate that, but try to focus your comments on what has not been said yet. We would like to hear from as many commenters as possible, and you can help us by doing that by not repeating things that have already been stated. So we're now ready to begin with the substantive portion of this meeting. So as you know, there is one agenda item for this meeting, consideration of the tentative decision in the matter of Park City Wind LLC, EFSB 20-01, DPU 20-56, 20-57 petitions by Park City Wind to construct and operate offshore and onshore cables and a new substation in the town of Barnstable, Massachusetts. So I'm going to begin by calling on elected and appointed public officials who have signed up to speak regarding the tentative decision.
We have the town manager from Barnstable, Mark Ells, who has pre-registered. Good morning.
Good morning.
Good morning, Mr. Ellis. Nice to see you here. Thank you for coming
Thank you very
to
much.
Boston. We appreciate seeing you in person.
It's a rainy ride, but that's okay. Good morning, Secretary Tapper, Chair Tapper, members of the Energy Facility Siting Board, and Presiding Officer Shea. Thank you for providing me the opportunity to speak. My name's Mark Ells, and I'm the town manager of Barnstable. As you know, the town has a well-established record of supporting renewable wind projects. This track record includes a leadership role in the Commonwealth as a host community for the Vineyard Wind project. Town staff worked very hard to successfully negotiate a host community agreement with Vineyard Wind, and countless hours of staff time have been dedicated toward coordinating with Vineyard Wind to move the project forward in construction and toward completion. Before this proceeding begins, the town entered into an HCA with what is now called Park City Wind for its project. That HCA was ultimately amended and restated in May 2022. With these two HCAs in place, the town got contractually agreed upon protections and financial benefits, avoided a possible repeat of years of litigation experienced in the Cape Wind matter, and put its support behind the Commonwealth's renewable energy policy. Thus, in 2020, the town's involvement in siting board proceedings seemed unnecessary in view of the host community agreement. More recently, however, there have been rapid changes in the complex wind industry and in the Park City Wind project, which neither the town, the siting board, and perhaps even the project proponent could have anticipated. For that reason, we are before you today and believe the town, as a host community for the Park City Wind project, deserves nothing less than a seat at the table to be heard. It is critically important that the town, in the current ever-changing circumstances we find ourselves in, be able to effectively represent the town's interests and the interests of its residents on any new development involving the Park City Wind project, which is why the town believes its intervention in this siting board proceeding should be allowed. The town continues to support renewable energy and climate resiliency, and I'm not here to question those policy goals. I am here, however, to try to make sure that the permitting requirements for the proposed project, if approved, are the most protective of the town and its residents, including their public safety, health, protection of our water resources, and to ensure that robust emergency response plans will be in place. We've reviewed the tentative decision and I wish to call to your attention areas of concern that still need to be addressed. Many of my comments are informed by lessons learned in the Vineyard Wind project and the recent changes in the evolving wind energy landscape. The town's petition to intervene in this proceeding raised several concerns. We understand that staff to the board have recommended that the town petition be denied. We feel strongly that if the town's original petition to intervene is denied, the town should be allowed to intervene for the limited purposes of presenting arguments in support of adding certain conditions without reopening the hearing. The town has filed a motion to this effect this morning. Allowing this motion will work no delay or prejudice to the Park City Wind or this proceeding. We do recognize that the board's tentative decision, if issued after our motion was filed, incorporated conditions contained in the host community agreement that set industry-leading protocols, design standards, containment, and other requirements intended for the protection of the town's water supply. We wish to reiterate that those conditions should be treated as minimum standards, and more robust conditions should be imposed as appropriate. We also appreciate that the tentative decision included, as requested in our petition to intervene, a performance deadline requiring Park City Wind to commence construction within 3 years of the final decision. While we had hoped for more comprehensive performance requirements and continue to believe that the board should require that a power purchase agreement be in place, we support a deadline for commencement of construction. I stress the importance of deadlines because the project's delays, including those created by Park City Wind itself, are causing challenges in the planning, implementation, and to some extent funding of the town's sewer installation program under its Department of Environmental Protection approved comprehensive wastewater management plan. These delays are undercutting the benefit anticipated by the town of coordinating the town sewer effort with the Park City Wind project. The comprehensive wastewater management plan is an essential component in the town's partnership with the Commonwealth to improve and restore water resources and protect the sole source aquifer on which our residents rely for their drinking water. Implementation of the comprehensive wastewater management plan, including planning, design, timing of state and local funding components, scheduling, and constructing a many-phase project is very complex. We need to avoid delays and complications in the town's water quality efforts by avoiding unnecessary and delays injected from other projects. We need not debate what others may consider to be the extent of the impact. Rather, we need to avoid the financial and environmental impacts to the town's implementation of its comprehensive wastewater management plan caused by the Park City Wind project delay. We also recognize that the tentative decision speaks to noise and magnetic field concerns. As covered in the town's comments submitted last week, the town requested that the board include further follow-up on magnetic fields to require a compliance filing to address whether the real-world impacts are no greater than those modeled in the decision. We appreciate that the board staff have recommended a condition for doing that at Craigville Beach, but we believe the requirement should extend to the onshore cable route and at the substation. We continue to ask that noise concerns are followed up on and reviewed as soon as reasonably possible and not necessary where the project is capable of full operation. Finally, I would like to speak to two additional issues: construction concerns and public safety. First, our experience with Vineyard Wind construction work has been challenging for our residents and their quality of life. We are a community of year-round and seasonal residents. Clear and limited hours and methods of construction are essential to protect public safety and maintain a livable community during such construction activity. The town's police, public works, and communications department have expended significant staff resources in continuing efforts to keep Barnstable safe and functioning during the project's construction. The town requests the board's decision be updated to include more robust requirements for a detailed construction and sequencing plan prepared in coordination with the town and state officials that addresses the pace of work, traffic management, key milestones, and appropriate amounts of project load and proposed work changes. Other important elements include sticking with construction sequencing unless approved otherwise, minimizing impacts to sensitive areas identified by the town, and restoring roadways as quickly as possible. The plan should require an experienced project management team to routinely coordinate with the with the town on project supervision and execution of work. If helpful, we can provide more detail to the siting board on useful roles and responsibilities within the plan. With respect to work hours, town residents have routinely experienced contractors' trucks and employees arriving on site well before 7 a.m., many times 5 a.m. to wait idle, and it interrupts those residential areas where this construction may occur. The town respectfully asks for reinforcement of what it means by work hours, which should specifically include the reinforcement that the contractor and its employees must not arrive at work locations at all before 7 and must conclude their workday by 6 p.m. unless approved otherwise in writing by the town. The town would prefer that requirements and what they mean are more firmly set, rather than considering this a local matter that is the cost of doing business. The board's staff recommendations unfortunately propose to go further in the other direction to allow Park City Wind to override the town with board's approval and work longer hours to the detriment of quality of life of the residents in their homes. Regarding public safety, the town's December 6th letter refers to condition P and the use of non-PFAS containing foams for public safety response. The proposed substation is located in a Zone 2 area of contribution to a public drinking water supply wells. Potential impacts to the sole source aquifer and the town's drinking water supply must be avoided at all costs. The board should consider prohibiting the use of PFAS, and for that matter, any other material used in an emergency response that could affect groundwater resources. We note that the town has spent over $27 million to date remediating and mitigating PFAS contamination in the town. We appreciate that the tentative decision requires Park City Wind to prepare an emergency response plan for the substation. We would ask for more detail as to what needs to be in that plan. Either consultation on what would be included in the emergency response plan, what firefighting materials would be used, how those materials might affect groundwater, how those materials would be contained and removed, and how Park City Wind would respond to a fire or a catastrophic event. If dialing 911 is the primary element of their plan, we believe that is significantly deficient. In thinking about a potential catastrophic event, even if the likelihood is remote, the risks are significant and the roles and responsibilities need to be discussed and agreed upon by all stakeholders. In that regard, we think the train derailment earlier this year in East Palestine, Ohio, and the resulting environmental disaster should be reviewed as a cautionary tale and something we should not ignore as we think about how best to protect the town's water resources. The emergency response plan should not be static and placed on a shelf, but should be required periodically should require periodic review and coordination. If the town is not satisfied with the final plan presented by Park City Wind, the town should have the opportunity to request review by the siting board. Again, we've seen rapid change in the complex wind industry and to this project, many of which were not anticipated in early stages of the project review or at the time the host community agreement was finalized. As the Commonwealth is well aware, Cape Cod has a sole source aquifer with protections under the Federal Clean Water Act and the source aquifer regulations. And this is the aquifer from which this is the aquifer that is the source of our drinking water. Any and all activities on Cape Cod and in Barnstable must prioritize protection of that water resource. This is especially true in defined Zone 2 areas where a proposed project is requesting that the board issue waivers to zoning and allowances of land use that put at risk this essential resource. As the host community for this project, the town should be allowed to intervene in this proceeding to present arguments in support of adding conditions without reopening the hearing. Again, allowing this request will not work to delay or prejudice the Park City Wind or this proceeding. I appreciate the opportunity to comment and your careful consideration of the town's concern.
Thank you very much
Thank you.
for your comments. Do you happen to did you bring any hard copies of the most recent motion? Because I don't think any of us have seen it.
I think it's been sent, but no, I don't have what was sent
Okay.
in today.
Okay, thank you.
Okay.
Maybe during a break, we can.
I'll
have
remain
somebody
through the
print
hearing,
that
so
out
if you
for
have
us.
any questions,
Great.
and I know Attorney McLaughlin from the town of Barnstable, as well as others are on Zoom. Thank you.
Great, thank you very much.
Okay.
Secretary Tepper, we did not have any other pre-registered public officials. However, State Representative Ziaros contacted me this morning and sent a comment letter and asked if I would read it into the record for today. It's rather brief, so I think I could do that with your indulgence.
Yes, please do.
Okay. Dear Secretary Tepper and EFSB members, I hope this letter finds you well. As a concerned resident of Barnstable, Massachusetts, I urge the EFSB to take immediate action on these matters during its December 11th, 2023 hearing regarding the Park City Wind project. Specifically, 1, grant the town of Barnstable's petition to intervene, reopen the hearing to allow the town to present new crucial information that has surfaced since the initial EFSB hearing. This step ensures a complete and accurate record, enabling the EFSB to consider all relevant details before making a final decision. 2, deny or postpone the final decision. Refrain from reaching a final decision until the town of Barnstable is heard and public concerns are thoroughly addressed. Key concerns include contamination risks. Evaluate the risks associated with a potential transformer fire, explosion, and the leak of toxic fluids stored at the proposed substations. Enforce regulations related to Mass DEP, sole source aquifer, the Federal Water Pollution Control Act, the Safe Drinking Water Act, the Water Resource Conservation and Recovery Act, and the Superfund Act. Supplemental environmental impact statement. Given new information, we require a supplemental environmental impact statement for the Park City Wind project. Community concerns. Address residents' concerns about the project's impact on the environment, health, safety, and the clear cutting of forested lands for substation construction. Project viability. Receive evidence from Park City Wind demonstrating the project's likelihood of being built and contributing to regional energy supply at the lowest possible cost in the foreseeable future. Thank you for your attention to these critical matters. Your careful consideration and action on these issues are crucial to safeguarding our community's well-being and the environment. Respectfully, Stephen Ziaros, State Representative.
Thank you. Can we see, are there any other public officials that would like to present this morning?
If you're on Zoom, please raise your hand. I think we see one.
That was Mr. McLaughlin. Put his hand.
Okay, did you move him to the panel by chance?
Put his hand down, so
Okay, Charles McLaughlin, who is senior counsel for the town of Barnstable, is requesting
Okay.
an opportunity to speak. See if we have him in the panel. Don't see him. Ah, there he is.
Good morning, Secretary Tepper and members of the board and Hearing Officer Mr. Shea. Thank you for taking the time to hear our comments. We received the draft proposed amendments to the tentative decision after close of business on Friday, and 4 of us in the legal department have been working all weekend to construct in a red line format and hopefully a helpful format for the board comments to the proposed amendments. We've also suggested some modifications to the draft findings with regard to the proposed denial of the town's motion to intervene. And we think that it would be helpful, and I look to you for guidance and direction as to how best to present those materials. We made every effort to get these things out at literally at the crack of dawn this morning to you, having worked on them till late last night. I regret that that's one of Murphy's many laws, subsets, we ran into a computer problem that delayed delivery until about 9 a.m. And even now, I'm not sure that the computer problems that we were working on have been fully resolved. But so with apologies, we did our very best to get materials in front of you on very short notice. And I will certainly look to you for guidance on how you'd like procedurally, mechanically to consider those, to hear comments as you might wish from us in terms of the red line suggestions. And finally, with regard to the proposed timing of a decision in this matter, I'm thinking, and I know that Attorney Ed Kirk from Barnstable, very well regarded local lawyer and a very prestigious family in the world of legal considerations. Ed has submitted a letter to you asking for an opportunity perhaps to have a final vote on this matter postponed in some way that would allow he and his clients to more opportunity to present. But it does strike me, given the admitted late hour, albeit compressed and expedited as best we could, to suggest respectfully that we will work with the board in whatever kind of schedule you wish that would make for an orderly presentation of our suggested edits and comments. So with that, I will not get into the details until I'm invited to do so. It strikes me perhaps procedurally that having given you that short introduction, I'll wait for your cue as to when you'd like us to get into more detail. And so unless you care to hear more from me, I'll go back and hold and participate remotely. Thank you.
Thank you, Mr. McLaughlin. Just so that I understand physically where things are. Have all the documents now been filed online?
They have been. I got a note from my colleague suggesting there might be the need for an edited correction of one of the documents, and I'm going to have to check that during a break with him to see if we do need to substitute. But for all intent and purposes, our documents, our work is done. I've got to make sure that the documents that, again, were delayed by computer issues this morning are the accurate documents that we want in front of you. And I'm
Okay.
wonder, frankly, given my colleague's comment to me by text, that may not be the case, but you should be able to have those documents this morning. So
Okay, so why don't we do this? Why don't we continue on with the hearing? And I'll hear from attorneys about how you'd like to proceed procedurally later on.
thank you very much.
Okay. So before we move on, are there any other public officials who would like to speak to the board this morning?
If you are remote on Zoom, please use the raise hand feature at the bottom of your screen. If you're dialing in, dial *9 to let us know. And again, this is for public officials. We see Mr. Carroll raising his hand. I'm not aware if Mr. Cliff Carroll is a public official or I believe a public commenter. So Mr. Carroll, we'll get to you when we take public comments a little bit later. Yep.
Okay, thank you. We're looking forward to hearing your comments, sir. Okay, so having there be no other public officials who'd like to speak this morning, I'm going to ask presiding officer Robert Shea to present the tentative decision.
Thank you, Secretary Tepper. Good morning, Chair Tepper and members of the Siting Board. My name is Robert Shea. I'm a staff attorney with the Siting Board and the presiding officer in the matter before you today, EFSB 20-01, DPU 20-56, 20-57, Park City Wind LLC. With me here today are the other members of the Siting Board staff who worked in this case: Andrew Green, the Siting Board Director; Joan Foster Evans, the General Counsel to the Siting Board; Wayne Wong, the Assistant Director of the Siting Board. We are here today to present the tentative decision in the Park City Wind case and to answer any questions you may have. Before I address the tentative decision itself, I should address the one outstanding procedural matter. On November 20th of this year, the town of Barnstable filed a document that contained both a late filed petition to intervene and a motion to reopen the record. Park City Wind filed an opposition 1 week later. The Siting Board staff has drafted a ruling denying the town's petition to intervene and its motion to reopen the record. We have incorporated this ruling as an amendment on the amendment sheet you received, and we recommend including the ruling in the final decision. This proceeding commenced on May 28th, 2020, and the deadline to submit a petition to intervene was October 28th, 2020. Therefore, the town's petition to intervene was filed 3 full years after the due date. The town gives various reasons for allowing intervention at this late date, but in the proposed ruling, we find them unpersuasive. Clearly, Barnstable could have sought to intervene over 3 years ago at the intervention deadline, or it could have even submitted a late filed petition to intervene, but at a much earlier time than it did. Barnstable's petition to intervene was filed after the board announced the upcoming release of the tentative decision and this board meeting. In brief, much the same reasoning applies to our recommended amendment to deny Barnstable's motion to reopen. I would like to note that the Secretary provided a summary description of the project that I will not repeat. The TD before the board today finds that the transmission project, using the company's preferred route and subject to the conditions contained in the TD, will meet the required Siting Board standard for approval of a jurisdictional energy facility. Specifically, the TD finds that the project will provide a reliable supply of energy for the Commonwealth with a minimum impact on the environment at the lowest possible cost. Accordingly, the TD recommends approval of the Park City Wind transmission project. The tentative decision is detailed and comprehensive and covers many issues. I would like to focus my remarks on a few key issues, including 1, the need for the project; 2, the project route and siting selection; and 3, environmental impacts. These issues have been raised by interveners and some members of the public that have commented on the TD. The need standard applicable to this case was established in the Siting Board's decisions in Cape Wind and Vineyard Wind. In both those decisions also involved a transmission facility that would connect a new offshore wind generating facility in federal waters to the regional grid. The Siting Board established a 2-part test to determine whether such a transmission facility is needed. First, the siting board determines whether the transmission facility would be able to interconnect to the grid absent the proposed. I'm sorry, it determines whether the generating facility, would be able to interconnect to the grid absent the proposed transmission facility. Second, the siting board determines whether the new offshore wind generating facility is likely to be able to contribute to the regional energy supply. The first part of this test is easily satisfied here. The proposed offshore wind generating facility would be located 41 miles from Cape Cod. Needless to say, there is no grid interconnection point located near the proposed facility. Therefore, the TD concludes that the generating facility would not be able to connect to the grid unless the project is constructed. Regarding the second part of the test, the board's decisions in Cape Wind and Vineyard Wind require that the petitioner show, quote, indicators of progress in order for the siting board to conclude that the generator is likely to be available to meet and contribute to the regional energy supply. Some commenters have argued that the recent termination of Park City Wind's power purchase agreement should be disqualifying in demonstrating needs of the siting board. First, this argument is contradicted by precedent. In both Cape Wind and Vineyard Wind, the siting board approved petitions to construct without requiring that PPAs be in place. The siting board has not limited the factors it will consider for progress to simply executed PPAs. Additionally, the TT finds that the wind generating facility and the transmission lines to support it have made important progress regarding environmental review and permitting. Some of these items include a MEPA certificate issued on the project's FEIR, a development of regional impacts decision issued by the Cape Cod Commission, a 401 water quality certification issued by Mass DEP, orders of conditions from the Nantucket Conservation Commission, and with respect to Edgartown, a wetlands bylaw permit by the Edgartown Conservation Commission, and a superseding order of conditions from the Mass DEP. Article 97 approval from the Massachusetts General Court for an easement at Craigsville Beach. The host community agreement reached with the town of Barnstable, which provides important impact mitigation provisions and other benefits to the town of Barnstable and its residents. And importantly, the tentative decision is also conditions any construction of the project upon receipt of federal approvals overseen by the U.S. Bureau of Ocean Energy Management. On the financial side, Park City Wind has been allowed to participate in the upcoming ISO New England forward capacity auction and has indicated its intent to bid the wind project in ongoing regional solicitations for offshore wind power, including one being conducted in the Commonwealth. The TD concludes that Park City Wind's generating facility has met the standard articulated in siting board precedent, and that the project's interconnecting transmission facilities are therefore needed. I will turn now to several key environmental concerns raised by some interveners and in public comments. The first issue is the location of the transmission facilities in Barnstable. In the route selection section of the tentative decision, the siting board describes a selection process the company used. First, it identified a number of existing substations where the project could potentially interconnect to the grid. Second, it evaluated potential onshore substation sites in the vicinity of the West Barnstable substation. The West Barnstable substation was determined to be the best point of the grid interconnection for Park City Wind. Third and lastly, the company assessed the possible landfall locations where the cables would come ashore. The company used both quantitative and qualitative screening criteria in performing the site selection analysis that are consistent with the siting board practice and precedent. The tentative decision finds that the locations selected by the company did not clearly overlook clearly superior options. Although Ms. Johnston and several commenters suggest other locations for the project not in Barnstable, the tentative decision does not find any such locations to be clearly superior to the proposed project, which is located in Barnstable. The next issue is the magnetic fields at the Craigsville Beach landfall location. The siting board's standard of review is that a petitioner must show that its proposed facility minimizes costs and environmental impacts while ensuring a reliable energy supply. The TD addresses the issue of magnetic fields in all project locations from offshore cables to the grid interconnection line that reaches the West Barnstable substation. Some public comments are particularly concerned about magnetic fields at the Craigville Beach landfall. The company predicts magnetic field levels by models, and it modeled magnetic field levels at the Craigville Beach landfall at 2 locations. First, the middle of Craigville Beach, and second, at the edge of the beach abutting the parking lot. The company reported maximum modeled magnetic fields of 4.3 milligauss and 28.8 milligauss respectively for the middle and landward edge of Craigville Beach, directly above the offshore export cable conduit. These figures assume 100% line loading. At 50% line loading, which is the expected average line loading of the cables, the magnetic fields were halved. The TD finds that the company's modeling is based on conservative assumptions. For example, the modeling assumes a current cable burial of 22 feet in mid-beach, whereas the engineering design calls for a 35-foot burial. The 35-foot burial would result in the magnetic field levels being further reduced at ground level. The TD concludes that the company has minimized the magnetic fields. The TD also finds that the project's range of modeled magnetic fields are comparable to values that it has previously approved in numerous proceedings, and that these values are, quote, far below, close quotes, the magnetic field safety threshold established by the International Commission on Non-Ionizing Radiation Protection. Therefore, the TD finds that the petitioner, has minimized the magnetic field impact. Next, the town has raised issues about the Centerville River crossing. For the crossing of the Centerville River, the staging area would be at 2 Short Beach Road, which is located on the southwest side of the Centerville River Bridge. The receiving shaft would be located north of the Centerville River on Craigsville Beach Road. The impact of the crossing of Centerville River would be temporary and limited to construction. The TD finds that with compliance with all local, state, and federal requirements and compliance with the conditions in the TD, the route selected by the company would minimize environmental impacts and would strike an appropriate balance among such impacts and cost and reliability. The next issue is the concerns raised regarding Barnstable drinking water and its sole source aquifer. The town's petition to intervene and reopen the record and numerous public comments have raised concerns about the potential impacts to the town's drinking water supplies and water bodies if there were spills from the project cables or transformers. First, the project has proposed to use cross-linked polyethylene cable that does not contain any fluids. This is solid cable technology, unlike earlier generations of utility cables that did sometimes contain various oil products for thermal cooling purposes. The cables are not a threat to groundwater supplies. With regard to the transformers and other equipment at the onshore substation, the draft environmental impact report notes that the containment system on the onshore substation site will contain approximately 125,000 gallons of dielectric fluid. This is the cumulative volume across 4 main transformers and other major equipment, each of which will have its own 110 capacity containment sump. Each containment sump also includes a full allowance for the probable maximum precipitation event, which is 30 inches of precipitation, in accordance with the recommendation of the town of Barnstable's consulting engineers. Also included in the design as an additional mitigation is a common drain system. All liquid from each individual containment area first passes through an oil-absorbing inhibition device. Next, the liquids flow to an oil-water separator. Finally, the liquids are directed to an underground infiltration system. In addition, the HCA with the town of Barnstable includes several important provisions to protect groundwater. The tentative decision finds that these mitigation measures minimize potential environmental impacts to water resources, including groundwater supplies. The next issue is intervener Jacqueline Johnson's concerns about substation noise. Jacqueline Johnson's property is a single-family house, and it abuts the parcel on which the onshore substation would be located. Ms. Johnson argues that the site for the onshore substation is unsuitable primarily because of its noise impact on her home. The company's noise modeling shows that the maximum sound increase over late night ambient conditions at Ms. Johnson's home is 8 decibels dBA. Ms. Johnson disputes this figure. In analyzing substation noise, the TD notes the company has promised to take steps to mitigate operational noise. These steps include, first, procuring built-to-order quieter equipment with built-in mitigation. Second, placing the StatCom units within a 3-sided sound barrier that will be 400 feet long and 30 to 35 feet high. Third, constructing a 90-foot long, 10-foot high sound wall. And fourth and finally, building smaller enclosures around the transformers and the shunt reactors. The TD imposes 2 conditions relating to noise at Ms. Johnson's residence. First, the TD directs the company to provide a pre-construction compliance filing that documents the noise profiles of types of equipment that would be used in the onshore substation. Second, the company is directed to provide a compliance filing within the first 180 days of full commercial operation, demonstrating that the onshore substation's actual noise profile is consistent with the model results. Ms. Johnson's disputes the modeled assumptions used by the company to estimate noise impacts at her property. But in the TD, the siting board has imposed meaningful conditions to ensure that these estimates are achieved when the project is built. Next, going to the staff's amendment sheet. The siting board issued the tentative decision for the parties on November 22nd, 2023. We received comments from 3 parties, the company, Eversource, and the intervener, Jacqueline Johnson. Eversource gives its full support to the tentative decision and does not request any changes. Ms. Johnson and the company do request changes. The staff have provided an amendment sheet that reflects requested changes to the TD. The company has requested a number of changes to the conditions in the TD. In general, most of these changes are sought to facilitate more efficient construction of the project or to maintain consistency with prior siting board precedent or other aspects of the record in this proceeding. Many of these changes requested by the company are included in the staff amendment sheet, with some exceptions. These changes include the ability of the company to request additional hours or days of construction when needed from the EFSB if the town rejects such a request. The company noted that the HDD, horizontal directional drilling, the HDD construction work hours in the tentative decision are Monday through Friday, 7 a.m. to 6 p.m. The company requested that the construction hours be extended to Monday through Saturday from 7 a.m. to 7 p.m. The town has opposed this change to the TD to the HDD construction hours. But the amendment sheet does not change these hours. The company also reiterated a need to exempt from time restriction all work that requires longer continuous duration, such as a conduit pull-in operations. And the amendment sheet does incorporate this change. The company proposal that traffic management plans be required 4 weeks in advance on a location by location basis as the construction work proceeds. The company clarifies that it may use firefighting foam as part of its emergency response planning, but accepts the tentative decision's restriction that these foams will not contain PFAS chemicals. To confirm noise modeling estimates, Condition R requires the company to submit a compliance filing regarding the onshore substation's actual noise profile within 180 days of commercial operation. The company wants commercial operation to be defined as the date the facility is installed and capable of delivering approximately 800 megawatts of energy. Condition R also requires the company to submit noise documentation from manufacturers of substation equipment, quote, when the equipment is procured, period, close quotes. The company wants to clarify that its obligation to produce the manufacturer-provided noise information can be fulfilled when the relevant information from the equipment supplier is made available to the company. And the amendment sheet reflects these changes. Regarding zoning changes, the company requests 3 zoning changes. First, it wants an individual exemption from zoning as it relates to tree properties that are not public rights of way. We granted this in the amendment sheet. Please note the staff would like to add to the amendment sheet some edits to footnote 142 on TD page 199 that were inadvertently omitted. We apologize. Footnote 142 should read as follows. The company acknowledges that it seeks amend exemptions to place transmission lines beneath public rights of way. The zoning petition, however, does not distinguish between the applicability of zoning restrictions to transmission lines beneath public ways and the applicability of the restrictions to any other type of land interest. In its comments on the tentative decision, the company identifies 3 locations of the onshore cables that are not in the public right of public ways. 1, the Craigville Beach Landing, 2 Short Bridge Road, and 3, a 0.2 mile segment within the Eversource right-of-way number 343. Consequently, to the extent that any exemptions sought in the zoning petition pertain only to the private right-of-way or to utility easements or any other right-of-way conceivably outside the scope of the Harrison decision, these properties are not part of the siting board's denial of individual zoning exemptions for the onshore cables and the public ways. Second, the company wants a comprehensive exemption for the whole project except the grid interconnection. We recommend this change in the amendment sheet. Third, the company wants to include the parcel at 6 Shoot Flying Hill Road in the individual and comprehensive exemption for the onshore substation. The use of 6 Shoot Flying Hill Road as part of the project was not included in the notice required by the zoning statute. Therefore, the board cannot grant the company's request and excludes 6 Shoot Flying Hill Road from the grant of individual and comprehensive zoning exemptions. Finally, we've corrected some minor typographical errors in the tentative decision, but these corrections are not on the amendment sheet. And in conclusion, the tentative decision finds that the Park City Wind project, subject to conditions, will provide a reliable energy supply with a minimum impact on the environment at the lowest possible cost, that it is necessary, serves the public convenience, and is consistent with the public interest. I would be happy to answer any questions now or later in the meeting.
Thank you, Mr. Shea. Appreciate the thorough explanation of the tentative decision. Does anybody have any questions for Mr. Shea? Any board members? No. I just have a couple, Mr. Shea.
Sure.
On the work hours, can
Yes.
you, I think I got a little lost in all the numbers. Can you tell me right now what the current work hour requirement would be if the amendments were passed?
Right, on the HDD work hours will be Monday through Friday, 7 a.m. to 6 p.m.
And is that consistent with what the town asked for?
That's consistent with what the town asked for. The company asked for Monday through Saturday, 7 a.m. to 7 p.m. So it's
Understood.
significantly reduced from what the company requested.
Okay, thank you. On the question on the noise
Noise.
mitigation, the 8 dBA modeled number, was that with the mitigation or prior to mitigation?
No, that was with mitigation.
With all those mitigation measures that you talked about would result in an 8 dBA increase at
Yes.
the property of the neighbor?
That is correct, yes.
And the condition requires a review of the EMF actual rating at the property line at commercial operation?
Yes, the EMF requires, I'm sorry, the TD requires
Sorry.
actual confirmation of the EMF figures on the beach. It's not at the,
Are you asking about the noise measurements?
I'm sorry, did I say EMF?
you said.
Sorry, I apologize.
Oh.
First for the noise. Yeah.
For noise, yes, yes, it does require confirmation after the project has gone to into full operation.
At my experience with these offshore wind facilities is that the time between when the project starts, some part of the project starts operating, can be quite a long period of time from when all 800 megawatts are actually operating. And the way that the definition right now is defined is all 800 megawatts, am I right?
Well, we use the word approximately 800, so.
But the idea is the whole project's up and running.
Project, yes.
I mean, I wonder whether there might be a interim measurement that happened before. I mean, it could be a year between 400 megawatts and 800 megawatts. So I just throw that out to the board to think about whether there should be a earlier measurement of the noise to see where it was with some portion of the project operating. On the, I got a little bit confused on the dielectric fuel. And if this is something that the company should speak to, that's fine, just tell me so. So the 125,000 gallons, where is that?
Mr. Wong, I think knows better than I do about the dielectric liquid.
Good morning, Secretary. So as Mr. Shea had stated, the fluids are cumulative over the 4 main transformers in the substation and other equipment such as, if you could give me a moment.
Sure, of course.
Such as iron core reactors, such as the iron core reactors.
So that material is inside the substation, the new
Yes.
substation? And I got a little bit confused about the containment situation. So it's 125,000 gallons, right? Within the substation.
Yes.
And then what are the containment mitigation measures for in the case of an accident or an emergency?
Yeah. So for each of the equipment, such as each transformer, they
Each
have their
transformer.
own containment.
Okay.
So each
And
containment
that,
is.
I'm sorry to be like detailed, but is that containment within the substation
Yes.
or outside the substation?
It's within the substation.
Okay, so each one has its own containment.
Yes.
Okay,
And each of them is, as Mr. Shea explained, more than the volume of the dielectric fluid and contemplates an additional 30 inches of rain in the event of a powerful storm.
so is that the extent of the containment measures, or is there more?
And then, as Mr. Shea said, if that does go over, they all drain into the same common drain system that contemplates, as Mr. Shea said, oil absorbing capabilities as well as oil and water separation before it goes into an infiltration basin before it even gets outside of the substation.
Understood. Okay, thank you for that clarification.
Yeah.
I think I can, I guess the last question I have is on the, on the definition of work, in the conditions. I mean, it sounds like from reading some of the, comments that we've received that the experience thus far for the community has been with construction that, well, the work hours, people don't actually start working until 7. There's, sort of a gathering and trucks coming earlier. And I'm wondering what the definition of what work is that you intend.
Well, we did not define, the TD does not define the word work. In general, in construction, as you say, people do gather early because it's the cardinal rule of construction. You have to be there on time. So we didn't address that issue of when people can start gathering.
Okay.
I did hear, if I may interject, the town manager talk about vehicles that were parked waiting for the start of construction hours that perhaps might be idling. And if that is the case, I believe the tentative decision references the Mass DEP anti-idling regulations, which limit idling of vehicles at construction sites to I think 5 minutes maximum, so vehicles should not be parked with the engines running and people sipping their coffee from 5 AM to 7 AM. That should not happen.
Okay, thank you. Thank you, Mr. Shea, and thank you very much to the siding board staff. The tentative decision is very well written and clear. And you made our jobs easier by being so thorough. So thank you.
Thank you, Madam Secretary.
Okay. So we are going to turn to Park City Wind for their comments on the tentative decision. I note that Park City Wind submitted written comments, and can the attorneys please do an appearance?
Good morning. My name is Adam Kahn, here representing Park City Wind, and with me are Aaron Lang, Zachary Gerson, and Chloe Pippin.
Good morning.
Good morning.
You may proceed.
I'm one of the lawyers representing Park City Wind, and we'd like to begin our remarks with some comments from Ken Kimmel, who is Avangrid's Chief Development Officer. Avangrid is the owner of Park City Wind, and then we'll be back for more comments on the tentative decision.
Okay. Mr. Kimmel.
Good morning, everybody. It's a pleasure to be here with you. I think the last time I was in a siting board hearing, I was sitting in one of your seats, so I know how much time and effort goes into crafting these decisions, and it's very much appreciated. I would agree with Secretary Tepper. This is an extraordinarily well-crafted decision. We appreciate the chance to comment on the tentative decision and to make some suggestions to make some changes to it, some of which were granted, some of which were not, but we're certainly satisfied with the tentative decision as written. I do think this is a very important case. A lot of heat has arisen about the project, but the bottom line is the biggest challenge we face on climate change right now and solutions is not developing new technologies or new policies, it's deploying the ones we have. Everyone in this room, I think, is proud of the progress of Vineyard Wind. We are especially appreciative of our relationship with the town of Barnstable that has made that project possible. But I think we all know that that one project doesn't get us anywhere near our climate goals, and hence the rapid deployment of projects that are in the permitting line to get them to completion and operation is the critical exigency, I would say, for the Commonwealth in meeting its policies. This project is at an extraordinary level of maturity. We have received all of our local permits from the Conservation Commission, from the Cape Cod Commission. We've received certification from Mass CCM and Rhode Island to the federal government, attesting to the fact that the project meets all of the state's individual coastal policies. We're expecting a record of decision from the federal government on March 1st of 2024. And all final federal permits by June 1st of 2024. If we are fortunate enough to have a bid awarded, we would expect to start construction expeditiously. So I do believe that this project directly meets the goal of rapidly deploying the technologies we have to address our climate challenge and to help Massachusetts meet its very ambitious 2030 target. I just want to comment briefly on Mark L's comments. First of all, I want to second, we have had a outstanding relationship with the town of Barnstable on Vineyard Wind 1 and on Park City. It has been one characterized by collaboration and dialogue and us finding ways to contribute to the community and to minimize impacts. And regardless of what happens with the motion to intervene or any of these conditions, that's going to continue. That's not going to change. I would say, however, on the motion that was filed today, which we haven't had a chance to review or digest, and I don't know what's in it. I think our lawyers are probably reading it, but really we haven't seen it. I would say a couple of things. One is the host community agreement we signed is a living document. It's not set in stone. It calls upon the parties to continue to confer, to work issues out. And some of the issues that I heard Town Manager Els raise about working hours and the like are exactly the types of issues that belong in that host community agreement. I'm not sure that they need to be adjudicated by the siting board. So I think We do wish we had had an opportunity to have that dialogue about these conditions before this morning. We also certainly would have appreciated seeing any additional conditions during the timeline that was given to everyone, interveners, non-interveners of, I believe, last week to submit comments. And then we'd be in a position today to respond to them and say if there's ones that the town are suggesting we can live with. So I would suggest that this comes just too late at this point to really have the opportunity to review it. I think allowing a party to come in at this late hour and intervene really sets a really regrettable precedent, particularly when we think about the goal of timely decisions by the Energy Facility Siting Board so we can advance these clean energy projects. But I would say this, if you are going to allow the town to present these conditions that were just filed this morning, we would like the opportunity to review the motion, maybe during a break, and to report back to you on whether there are some conditions that we can live with. To give you an example, I understand that one of the revised conditions is a more elaborate magnetic field monitoring. Well, the local conservation commission in its order of conditions has that in it. So it could be that what the town manager is asking for is something that's already in an order of conditions, in which case we probably won't object to it being in the siting board decision. But the point is we haven't seen any of this. We haven't had a chance to digest it. And I do think it comes too late to be considered at this stage. So I'm going to leave it there and ask Adam and the attorneys to take it.
Thank you, Ken. I'd like to introduce some other members of the Park City Wind team who are here. Elizabeth Johnson, who is Park City Wind's project manager. Hans von Lingen, who is Avangrid's state environmental permitting manager. Doug Sarnomsky, who is Park City Wind's onshore package manager, and onshore package manager means it is in charge of the land-aside construction. And Holly Carlson Johnson of Epsilon Associates. By Zoom, we have some of the subject matter experts, just in case there's a need for them. Kenneth Fitzgerald from Stantec, Clint Sir of Epsilon Associates, and Chris Long of Gradient Associates. So I won't try to repeat what Ken said, but I would like to extend our personal thanks to the siting board staff who have worked on this petition for more than 3 years, 3.5 years. We appreciate their thoroughness and diligence. They had an immense record from which they could draw. It was assembled over those 3.5 years. There were multiple interveners in these proceedings. There were 10 days of evidentiary hearing. There were more than 15 witnesses. There were multiple rounds of information requests and record requests, and nearly 600 exhibits were entered into evidence. This is a very substantial and well thought through, it was a highly developed record and a very substantial and well thought through tentative decision. So we'd like to thank the staff for their excellent work. At this stage, we do have a few comments about the tentative decision, and we'd also like to address noise in our comments. So first, I'm going to turn it over to Zach Gerson, who's going to talk about the tentative decision and some of the changes that were made to it.
Good morning.
Good morning, everyone. As Adam said, my name is Zach Gerson. I'm one of the attorneys representing Park City Wind. I will briefly address the comments that Park City Wind submitted on the tentative decision. I'm going to bypass talking about the tentative decision as a whole. I want to reiterate that the tentative decision as initially proposed on November 22nd was thorough, well-reasoned, consistent with precedent, and protective of health and the environment. As strong as the tentative decision was when it was initially proposed, Park City Wind submitted comments on the tentative decision on December 5th. Those comments recommended changes to improve the clarity, precision, and effectiveness of the decision. As we just heard from the presiding officer, the siting board staff has proposed changes to the tentative decision after receiving Park City Wind's comments and the comments of others as well. Incorporating those proposed changes makes the tentative decision even stronger. Park City Wind fully supports approval of the tentative decision as amended And to be clear, this includes acknowledging that some of the comments Park City Wind submitted were not adopted. While Park City Wind believes that its comments on these issues were warranted, it accepts the staff's decisions on those various issues and urges approval of the tentative decision as a whole. I want to briefly address a new condition that staff has proposed to the original tentative decision. This condition would require magnetic field monitoring at the landfall site following commercial operation. Park City Wind does not oppose this condition and truly appreciates the siting board's leadership in overseeing magnetic fields, given its expertise in this area. Thank you all for your time. I'm going to pass it off to my partner, Aaron Lang, to discuss some issues related to noise. And as has already been said, we have a team here to answer questions.
So just to be 100% clear, the company has no problem with the amendments that the board has, that the staff has proposed at this time.
At this time, the company Park City Wind supports approval of the tentative decision with the amendments that the same board staff circulated.
Okay, thank you.
Thank you, Zach, and thank you, members of the siting board. As Zach mentioned, my name is Aaron Lang. I'm also counsel for the company in this proceeding, and I'd like to briefly address the topic of noise and add to the description that presiding officer Shea gave just moments ago. So the tentative decision found Park City Wind engaged in a thorough and comprehensive noise assessment when it comes to the substation, and that assessment included modeling sound level increases at 13 different offsite locations, residential and commercial locations, using techniques and information that are standard for siting board proceedings and include several conservative assumptions. I want to highlight a few of them. The first is that the substation equipment is assumed to be operating at 100% capacity. That is, each piece of equipment would operate at that capacity, and that just for clarification, does not reflect what would be a typical operating activities at the substation. The other assumption was the Park City Wind measured ambient sound levels to compare against the modeled sound level increases at a time of the year and late at night that is particularly quiet. That was in mid-January, and the Park City Wind also measured ambient noise levels during the day and found that those were 10 to 15 decibels higher thereabouts, mainly because of the proximity of the substation site to Route 6, which is heavily trafficked. So they used the low nighttime levels for it as a basis for comparison. And that, in any event, that being the case, the modeling shows that the substation noise, the levels that were achieved, will be consistent with the Mass DEP noise standards, and in fact, they will be below the Mass DEP noise standard of 10 decibel increases over ambient. Now, it's true that information about the sound generated by each piece of equipment is not available and could not be included in the model. And this is because the substation equipment that will be procured has to be custom designed and custom built to Park City Wind specifications. But to be clear, all potential manufacturers of that equipment will be given the sound estimates that Park City Wind submitted to the siting board, and that will ensure that the equipment is designed to those specifications and is consistent with the modeling results and lower than Mass DEP noise standards require. Under condition R of the tentative decision, the siting board will have confirmation prior to construction regarding that equipment and the sound levels that it will emit. And we'll have the opportunity to ensure that it meets the levels that were presented or goes below them. This goes far beyond what the siting board typically requires for noise assessment, which does usually include post-construction monitoring. The condition also includes post-construction monitoring as well, so that will be an added layer of protection to ensure the accuracy of the model. So in sum, Park City Wind supports the tentative decision as modified, including condition R, and will comply with that decision and believes that it is confident that it will be able to do so. Thank you. I can answer any questions.
Do you have more to say, or would you like to have questions?
I only wanted to offer the chance to for the board to ask questions.
So does any of the board members have any questions for the company?
I have a couple. Yes, thank you very much for the comments and presentation. So one of the conditions, condition L, talks about the construction process and cable splicing, which may need to occur longer than the proposed construction hours. Can you talk about what evidence is in the record about the cable splicing and how long that would take?
I won't be able to give you specific citations, but we certainly can provide them. But the cable splicing is expected to be on a 24-hour basis during the periods that they occur. And I'm going to look backwards at the technical team to see if we have a time for how long each splice takes.
The amount of time for each splice.
I'm sorry, could I ask you one? Yes.
Would you mind stepping up to the microphone, please?
The amount of time for each splice is going to depend on the setup of the operation. And I wouldn't be able to give you an exact figure, but you would want to maintain a continuous operation in each splice vault until completion in order to keep the work flowing efficiently, which is why we would want, if possible, to continue the operations beyond the typical workday. It wouldn't be in every instance, but we would like to have that flexibility in order to maintain a fluid workflow and to complete the work in as little time as possible.
Thank you. And can you estimate, are we talking about a number of days or months, the 24-hour periods? I'm just trying to get a sense of how much time this actually would take in a 24-hour cycle.
It would not be more than months of 24-hour operation. The entire cable pulling campaign, I don't have the figure in my head, but I think it's on the order of 6 weeks-ish. But we would not need to go around the clock for every operation.
Thank you. And you're saying 6 weeks over the duration of the entire construction for all components of the
Duration of
project?
the entire project.
Thank you.
Yeah.
Hi, Elizabeth Johnson, project manager. Just to supplement Doug's response, I'd say typical if we're just talking about one individual splice, I'd say on average it's a 1 to 3 day operation. It can be impacted by time of year and weather, as the temperatures can impact the efficiency in which the work can get done.
I'm sorry, air efficient complex.
In which the work can be done.
Thank you. And can any of the company representatives just talk about how far in advance you would know that those 1 to 3 day periods would need to happen? As in, is that something that could be communicated to the town in advance?
Yes.
Yes, it would be something that would be part of like the construction planning. So it'd be easily communicated ahead of the work in coordination with the construction contractors that'll be performing the work. So certainly something the town would have ample notice about.
Thank you very much. And if I can, just one more general question. So I appreciate that the company has had good conversations with the town of Barnstable. Could you just explain any information that's in the record about communication with the general public who are not elected or appointed officials from the town?
There have been in the record, in the DEIR and in the analysis, there are lists that were at the time those were complete of public meetings, excuse me, and meetings with elected representatives. There have been also a series of open houses for the public to come in where Park City Wind would be available to answer questions. Those are advertised broadly and are very well attended. And there have also been meetings with neighborhood associations and individuals. We have an outreach staff that is really looking to promote awareness of the project. We have a project website where all the permitting documents can be found, as well as the contact information for any of the outreach people who can supply information that is that's been requested of the public from the public.
Thank you very much.
Maybe just could I have a follow-up question to that? And this may be directed to the company or maybe to the town administrators, but to what degree is the general public aware of or involved in sort of the development of the host community agreement? I appreciate the fact that you say it's an organic and evolving document, but I'm just wondering who represents the town, or I guess the basic question is, how much is the public aware of that, and is there any involvement in them determining what sort of things you'd like to see in that?
I think I would have to let Manager Els describe what the specific processes within the town of Barnstable were, but I can say that the host community agreement was the product of long negotiation. It was and the process was approved of by the Barnstable Town Council, who authorized Manager Els to conduct those negotiations and ultimately to execute the agreement. But more information, I think, would need to come from Manager Els.
Thank you.
Any other questions from board members? I had one on the fuel, the oil, the 125,000 gallons. I don't, as a layperson, I don't really have a sense of like what that means. Is that a lot? Is that a little? Like, is that typical? What does that mean? It sounds like a lot when you just read 125,000.
Well, I'd like to say a few things about that. But first, just to clarify, it's not fuel. Sorry. It is dielectric fluid that is not designed to be consumed. I'd also like to mention that the containment systems that are designed are proportional to the volume. So at some level, the specific amount of fluid, the systems are designed to cover that specific amount of fluid. And as was earlier described, there are redundancies on that system. 125,000 gallons. I'm trying to think of what I think a tanker truck is on the order of 10,000 gallons. Yeah, I think that's on the order of 10,000 gallons. So it would be multiple tanker trucks to fill the equipment.
If I were building a substation in a different place, would it be the same kind of level? I mean, is this just the typical thing in a substation?
Yeah, the substation is, the transformers are the transformers, and so they're designed to, that's how much fluid that they take. It's not greater or lesser than. There's certainly other designs of transformers and whatnot, but if this were built in a different location, it would have the same amount of fluid.
Thank you.
All right. One follow-up question on that. I presume this is the case because you're identifying an oil water separator as part of the containment, but presumably this type of fluid is such that it would be separated in an oil water separator.
Yes, that's a good question, but yes.
Okay. Thank you.
Okay. Thank you very much. Mr. Els, did you want to just talk for a minute about I think what the board is interested in is going forward, if this is sort of an active document, how would the community be involved in any changes that were made? Is that accurate?
Yes, thank you.
Again, thank you, Mark Els, Town Manager. I actually had hard copies printed and delivered of what we filed this morning.
Oh, great. Thank you so much.
Oh, I'm sorry.
Sorry.
Handed it to the wrong person.
No, you're fine.
I would also offer that you have a wonderful example, if you have the time, to look at what we've done on the Vineyard Wind project relevant to times of operation and where delays did occur that extended 24 hours, multiple day. A lot of it was related to the directional drilling. That's why we wanted it all done out of the beach. Relevant to the host community agreement, it is a contractual agreement between the two parties that laid out matters beyond what we would typically see a regulatory agency require in a relationship for a community that would host a cable landing and a cable traversing through the community. And as I've already shared with you, certainly this environment of offshore wind has changed and we've learned from it. So I would suggest, if I know time is of the essence, but I would suggest you take the time to look at what occurred in Vineyard Wind, because I don't think anything unique occurred there. And I think much of the approach that's being proposed will be replicated. It is of concern. And from a practical standpoint, having been in public works for 20 years, construction is complicated, and temperature and certainly unforeseen conditions, weather, all impact construction, and we know that. And so we want to be practical, but we also want to make sure that when we're in residential neighborhoods, that we're knowing of safety, health, and quality of life. Host community agreement focuses really on things that go beyond what we would anticipate, one of which being the containment system that you're asking about, that typically wouldn't be required at substations. The EFSB has approved substations, certainly on Cape Cod before, that contain these fluids. So we were very concerned as we saw this progress that we bring in an outside expert to help us go as far as we could in protecting. Now, most of that's focused on normal operations, not in emergency response, because in that situation, it can go well beyond what we would normally see perhaps in a leak of a fluid, you know, in some particular aspect of a substation. You know, I think that talking about it being a living document, I don't think that it is. It is a contract between the parties that identified at a point in time what we had identified as the primary issues. You know, two more real quick ones are, we were very concerned coming out of the Cape Wind project that any proponent not be allowed to interconnect into the cable that would come ashore in our community, meaning proceed with another project that we really had no say that would land and traverse through our community. Certainly the groundwater protection issue, certainly the financial aspects, and then many other details. So I think that the public was, through town council meeting, briefed on the major components of it, but the public was not at the table identifying the detail. In many cases, they were in the permitting process and design process for much of this. So it's difficult to say that, so it should be allowed to be adaptive, because such issues as emergency response, we don't know all the details yet.
I mean, there wouldn't be anything that would preclude the town from working with the company to amend the document if necessary, right?
I think that it would be a logical approach.
Okay, thank you.
As different and new information
Sure.
Became aware, you know, we became aware of that information.
Thank you.
Thank you.
Okay, we're gonna try to do the intervener in the proceeding, at least one right now. Can we hear from Eversource, please?
Alan, are you good? Thank you.
Thank you, Alan.
Good morning. I will be brief. My name is David Rosenzweig, and appearing with me is Mike Kaler. We're representing Eversource Energy. Eversource Energy was an intervener in this proceeding. It is the interconnecting utility that will take the output from the Park City Wind facility from its substation into the Eversource substation in West Barnstable to provide that to the grid. Good morning, Chair Tepper and fellow board members of the staff. We filed written comments on December 5th, and our written comments express our support for the TENUP decision. We also want to express our support for the staff amendments that have been proposed. including any provisions that relate to the grid interconnect line, which is a 7/10 of a mile, 345 kV line that will be underground within the Eversource right of way, connecting from the onshore substation of Park City Wind to the Eversource substation in West Barnstable. Eversource is the interconnecting utility. There is a particular condition, condition C, that the siting board's staff's tentative decision has proposed that would essentially put Eversource in the position of attesting to complying with all of the conditions that are applied to the grid interconnect line in the tentative decision as it becomes the final decision. And Eversource is amenable to complying with that condition and would intend it on doing so upon the board's vote to make the tentative decision a final decision. Just to wrap up, we do support the project. We do support the provisions in the tentative decision with the staff amendments as well as condition C, and we look forward to the board's vote on this matter.
Thank you. Does anybody have any questions for? Yes, Ms. Hypo.
I have one. Why intervene? Why not be a co-petitioner?
Well, that had to do with the genesis of the filing of the petition was done initially on its own by Park City Wind. We were not a party to that, but we did want to get as involved as possible in the proceeding. So we intervened as a full party and we provided responses to information requests and presented a panel of witnesses to testify with respect to the Eversource interconnection line so that that record was full and complete on all those issues. In the future, that might be an approach that could be used that co-applicants could be developed in this type of proceeding, and Eversource is not opposed to that as it relates to its own facilities. That just didn't happen here as a matter of course in terms of how Park City Wind filed its various petitions, but the same result has been achieved in terms of the content of the record, in terms of what measures will be put in place to make sure that the Eversource facilities are done in a safe and reliable manner. And with the condition C, it puts the siting board in the same position of being able to oversee and monitor the progress and implementation of that facility in the same manner as if it were done by the project applicant itself here at Park City Wind. So in the future, that might be a better way of proceeding, but the circumstances were as they were, and we've gone to the same point. So I think from our perspective, it's an appropriate resolution.
Thank you. Any other questions? Okay, so why don't we, thank you. Why don't we take a 10-minute break? It is, according to my phone, 11:21. So we'll start again at 11:31.
Most of it.
Thank you.
Oh, yeah. I was very old.
Very special project.
Yeah.
Thank you. Does this include, so this includes, oh, they let me mind the amendment. Oh.
Very busy. Okay. Yeah. It's been an interesting year, a couple of years. Where it's not been before. So yeah. Yeah, I appreciate it.
Yeah, you know that if I'm reading for the HCA right now, it doesn't appear to be a. Take it from the HCA.
Not bad. I thought it was a lot of and it's several a lot of people who don't there. And yeah, we're in the middle of the year. It's great. There's a lot of wind. We can change some jack. There's no way.
But you know, that's.
Yeah. The motion and he actually didn't, edit the TV, he edited the amendment sheet, which is not what they had said. Oh, I haven't met it, yes, I like to.
My grandson, but my daughter.
You talk about the name, obviously. Sorry. Thank you for coming back. You want to say it in most. If it's the first time you see it in your person, I'm not 40 years. Since people back in person, I think it actually looks much better. I mean, but I think this.
Yeah, really.
Because
all I have to do.
Letting it to you end up with this and the screen down there.
I did bring my own food. And I am.
So. This.
Are you holding up? You're good. Now that we're started and underway, you're good.
Yeah, everything's fine.
Yeah. Yeah, no, I want to talk to
We're into the.
I'm glad that you did.
That's a whole.
Yeah, we got,
Carolyn, they're down
we
there.
haven't figured out everything.
Yeah, so but she's following up since July, we're done. Good.
Yeah. Higher.
Higher.
I think it's higher.
Okay. That's what you.
Like,
Yeah.
Yeah. I'm gonna give them the water.
I'm only an interviewer here, so.
I know.
Oh. Oh. Yeah. Continue. Oh.
And it's in the EFSB. That I'll be pretty doing it, but
It's a hard talk.
Well, yeah.
like it or not, like it's gonna be a central. Climate change. Yeah.
Charlie.
Goes on and on.
Something here now. So we brought in. Anderson Krieger. And they ran it over. And they gave it. Yeah. Yeah, yeah, and if you stay on the week, you'll get what, about that, right? Yeah, I'm new. I'm new to you. My first. Well, yeah. I visited the county. But I used to think I was doing energy, but way back, engineering. Yeah, I know the market, so. Yeah. Oh, okay. Yeah, no. Years before. Yeah, I know, you speak time. I got my one question. Iron core, ion core.
That's okay. No, I'm glad you did. I wanted to meet them and I got to meet them. Realty. No, I saw something like cooked. Yeah. Over there.
Secretary. My name is Christopher. I'm going to change Jack Johnson, home. And agencies, my mind really looking for such specific. Appreciation of the opportunity to hear from you. Mr. Johnson has had been already not very beginning, but you can be period of time you can franchise as possible and change it very actively involved. So they've attended rounds of public hearings in which have been with everybody's strategic issue we're focused on. And I had great opportunity to speak and associate with witnesses, which I appreciate. Jackson Hall is not known in the inclusion of novels, except this is the folks that are residents who quickly generate significant staff. Now, there are well known in the immediate area. It's just about West. The bigger than 5 foot tall, very well, along the western. And just on the other side of the wall. This is Jackie's home, and has been subject to homes. Studies in the record in this map. One moment, they just received a message from the audience. That's not.
Excuse me, we're having, I think, some problems with the audio.
No. Oh. Reasonable time on it.
What does this, a lot of times this not say size. How many businesses?
So we're using Wi-Fi network.
In the state building.
Would it be better?
You want to test Regals? Greg or Jonathan, can you confirm that you're hearing? Yes. Okay, great. Thank you very much for letting us know. We appreciate it. Otherwise, we're quite unaware.
Thank you. You may proceed. Thank you. Back on the record.
Thank you very much. I'll
Sorry
begin
for the
at the
interruption.
beginning, if you don't mind. My name is Christopher Senning. I represent Jacqueline Johnson, who lives at 82 Shoot Flying Hill Road, which abuts the subject property. I'm very pleased to have an opportunity to appear before the board. I was indicating to you that we have appreciated all of the opportunity. Ms. Johnson intervened long ago in this matter during the period when that was available, and we have participated in hearings since then actively, and we've even had the chance to cross-examine some of the Park City experts and some of the Epsilon experts who did their sound study. So we're very glad to have this opportunity. As I mentioned earlier, my client's home is receptor D as shown in the acoustical model. And there are two other homes very close. In fact, one of the other homes is as close to sound producing equipment at the proposed substation as my client's. And there are two sound studies in the record. And that's because the other one, not directed at this proposal, is for Vineyard Wind, which has been mentioned a few times today. And the reason it's in the record, it was put in the record graciously by Presiding Officer Shea at my request, because the equipment is very similar, but the acoustical study was very different. And I wanted to be able to contrast for this board the difference between these two acoustical studies. In fact, I'll read from EFSB 25, a company response. Accordingly, the Vineyard Wind 1 connector substation includes many of the same components with the same scale and similar power characteristics as Vineyard Wind Connector 2. These are the two substations, the one that was already approved and the one that will be approved if your board adopts the tentative decision. You are very familiar with your approach to noise. You do depend on the Massachusetts Department of Environmental Protection noise pollution policy, which is not a regulation, but it is a policy with so much common sense and force that our court system allows witnesses to testify on whether a sound source does in fact increase sound above ambient by 10 decibels or more. And your board has adopted this policy. This policy was adopted in 1972 and re-upped in 1990. And it was just adopted by the office as a policy to be used when DEP goes out to see if noise pollution exists. So it's a very important and fundamental policy. Park City has made the point in their briefing that they should not have to comply with the 10 decibel allowance policy, but the siting board in the tentative decision has ruled in the opposite way and said, well, many of our decisions have used this policy. And I think that's very wise.
In the Park City acoustical study, the one that is the subject of this hearing, if you go into the two tables that are at the heart of that study, table 7-3 and table 7-4, which reviews 10 types of equipment and provides their sound power, you will notice notes to the grids. And in those notes, it is said that additional reductions in sound power were made. It's not explained in those notes why additional sound power was subtracted from the known sound power of these different pieces of equipment. It just says additional reductions. There are two types of substations. There's a gas insulated substation and an air insulated substation. You use the air insulated when you have enough room that you can allow your equipment to be spaced out enough so that air can cool the pieces of equipment. The Vineyard Wind substation is an air integrated substation, insulated. This one is on a site that is smaller, and in my opinion, too small. It's too small and too close to residences to fit a substation this powerful. And it will be a gas insulated substation, as it must be, because it is so small. And that adds $25 million to the cost of this substation that's been placed into the record by Park City. Here's Park City speaking about it, about why they didn't use an air insulated substation. An AIS facility inherently requires more space between equipment, and given the site selected for the proposed substation, project engineers determined that an AIS only design would not fit on the property. Okay, so here's information submitted into the record where we raise the question of the size of this property. It's about 6 acres. And it's got a lot of equipment going in that has a lot of sound power, and at least 2 of those 3 residences to the west are very, very close. Sound barrier walls. There are also a number of major sound barrier walls that are part of the site plan for this project. There's a 35-foot tall wall that goes 200 feet along the western side, the side on which my client lives. And there is another 35-foot tall wall and additional smaller sound barrier walls around specific pieces of equipment. These walls are already as high as you can go and accomplish any meaningful reduction of sound pressures at people's homes. And here's what the tentative decision says. The company asserts that any further increases in wall heights would result in diminishing returns for additional noise mitigation. The company modeled a 5-foot increase to the onshore substation's western sound wall that would cost an additional $250,000 and only result in 1 dBA improvement at the nearby receptors. My client's home is one of the nearby receptors. Epsilon ran its models before it removed sound power from the different pieces of equipment, and it failed. And it kept removing sound power from different pieces of equipment until the model met the DEP 10 decibel policy.
Sorry, can I interrupt you real quick? I don't know what sound power is.
Okay, when a piece of equipment is manufactured, an independent lab will measure the sound power of a piece of equipment. Most manufacturers get certified reports on the power of the sound power of their piece of equipment. Sound power is really the same thing as sound pressure. What Ms. Johnson will hear at her home is sound pressure. And that's what's measured. The 8 decibels above ambient that you mentioned, Madam Secretary, that's sound pressure. But when you get close enough and you want to know what is the potential to make sound of this piece of equipment, the technicians take a meter that collects a lot of data in different octave bands and walks all the way around that object 1 meter away. This is the international standard. And even though those are sound pressures, because it's so close to the piece of equipment, we refer to that as sound power. And if you are looking at the sound power of a given piece of equipment, let's say the 450 MVA transformer,
the manufacturer has had that tested in a lab and it has been certified that it has a particular sound power. And it produces octave band, the major octave bands, there will be a sound power level for each one, and there will be a broadband number. You've probably seen a number. This in table 7-3, they say that this transformer has a sound power level of 93 decibels. But individual octave band frequencies are also important and are also inputted into the model that gets used to create the contour map that was used here. Because if a source of sound is heavy on the lower frequency sounds, it takes more distance for those to decay. So it's very important to understand what sound powers are there at 16 hertz, 32 hertz, 64 hertz, and so forth. And in those two tables, a number of those low frequency measurements were missing. If you take a look at those two tables, there are a number of blanks there because they're missing. Each one also had a broadband number, a number that represents that sound power. So that's what sound power is, and sound pressure is what happens at receptors. So here's what Epsilon did. And they called this an iterative process. And I didn't know that word until they used it, but I
The
understand.
joy of becoming a lawyer, you've learned a lot about substation and noise.
Pardon me?
The joy of being a lawyer, you've learned a lot about substations and noise,
Oh,
probably more than you ever wanted to.
Oh my. So Epsilon, the acoustical engineering firm that Park City hired, engaged in an iterative process, which means iterations. It really means, in this case, trial and error. And they testified that we kept reducing sound power until the model worked. On cross-examination, I asked their experts, why did you do that? Why did you take 7 decibels off the 450 MVA transformer? That's the loudest piece of equipment going into the substation, and there will be 2 of them. And the answer was, well, we just landed on that because that is what it took to make the model comply. They took other sound power off of other equipment. Iron core shunt reactors, 3 decibels. Harmonic filter capacitor, 4 decibels. Air core shunt reactor cells, 15 decibels taken off in order to make the model work. Step up transformers, 18 decibels. Cooling fan
And you
bank, 2
say,
decibels.
I'm sorry, when you say to make the model work, you're saying to get under 10 dBA.
Yes. And that was what the testimony revealed. None of these additional reductions were done in the Vineyard Wind model study, done by the same company, Epsilon, for equipment that the company says is very similar in terms of sound power levels. This, to me, raises a red flag. This is why I wanted that other study in the record here. Something is terribly wrong with the modeling that produces a result for you that you're being asked to rely on, that at my client's home in the quietest part of the night, when she's trying to get restorative sleep, it will be 8 decibels above ambient. But to get there, to get to 8 decibels, they took all of that sound power away without an explanation, other than it was necessary, this iterative process, to achieve compliance with the 10 decibel noise level. Sound power flows through the model. I asked the Epsilon experts at the public hearing, if you take 5 decibels of sound power away and all other variables are kept constant, will that mean 5 less decibels of sound power at a receptor? And the answer was yes. It flows right through the model. So when they say they take 15 decibels off of a piece of equipment, if they did not do that, that 15, and they kept every other variable constant, that would flow through to the receptor. Also, those 2 tables that I referenced have much data missing. There are 17 individual octave band frequency sound power that are missing in those 2 tables. And the phrase data for several bands not available, or sound levels in some octave bands were not available, occurs in half of the 10 pieces of equipment that are analyzed in those 2 tables. Then we come to the question, did Park City and Epsilon provide manufacturer data to
confirm that you will have a good acoustical model if you take these decibels off? And can these pieces of equipment be manufactured with that in such a way that they will not have what you've reduced? Can we get it down to that level? Here's what the tentative decision says. The siting board shares Ms. Johnson's skepticism regarding the company's self-described aggressive assumptions regarding the noise profiles of its intended substation equipment. While the siting board does not prescribe specific types of evidence to support noise modeling in our proceedings, we do ensure that the results of such modeling are reasonable and enforceable. Here, the company has not been able to offer specific manufacturer-provided equipment specifications to support its modeling assumptions. Instead, it has relied on decades-old reference guides and made certain subjective noise reduction adjustments that were iterative to achieve model compliance with the Mass DEP noise policy. That's in the tentative decision. For me, this is remarkable. It's remarkable testimony, and it's remarkable that it has survived through this process and gotten itself into this tentative decision, which I think is very fair, because I think whoever the staff that wrote this decision was trying to capture what really took place at the hearings, and that's what took place at the hearings. You need to have substantial evidence to believe that there will be only an 8 decibel increase at my client's home at the quietest part of the night when she's getting rest. All the tentative decision is able to get to is the word may. It may comply. Here's what the decision reads. While there is reason to be skeptical of such adjustments, the company may, in fact, be able to secure equipment that meets these specifications and achieve the modeled noise levels at nearby receptor residences. That's just may. It's not probably will or likely to, it's just may. Maybe they can do that. And you heard today testimony from the company that that's our plan. We are going to give the manufacturers our specifications, including this model, this unscientific modeled study, and say, you have to make equipment that meets it. Now, in order for you to meet the substantial evidence test, I think you would need to know, you would need to get information from manufacturers that, yes, we can do that. Keep in mind that the 8 decibels at my client's home was after all of the sound power walls were plugged into the model and all of the additional reductions in sound power that I just listed for you. That is the result if that works. The tentative decision recognizes this problem, which I appreciate. I very much appreciate the honesty in this tentative decision, and it's accurate. It contains what I think the staff was trying to devise as a fix. A compliance filing that will happen after you make a decision approving this site for this use. It reads, in addition, to gain earlier visibility of the steps being taken by the company to achieve this result, the siting board further directs the company to provide a pre-construction compliance filing documenting the noise profiles of the onshore substation equipment types listed in exhibit VW-7 at 7-12 and table 7-3 when the equipment is procured, and any additional noise mitigation measures such as additional or taller sound walls that the company intends to take as a result. Now, there's a lot to unpack there. What this decision is saying is that your board should approve this project now, but ask that before it's built, there be additional information provided to you in a compliance filing. And I do not know if that's subject to cross-examine or examination or part of a public hearing, but it certainly should be. In fact, it should have happened already
because in order to make this decision, you should already be at substantial evidence, and I don't think you are. In fact, I think the compliance filing after the decision is actually intended to complete the analysis that should be going into the decision of whether or not this substation fits on this site. And the recognition is that the wording is, and any additional noise mitigation measures, such as additional or taller sound walls that the company intends to take as a result. As a result of what? Well, you wouldn't increase your wall height if the result wasn't that the model in fact doesn't work. This is already assuming that when there is this compliance filing after the decision, what really comes back is that notwithstanding the hope that is expressed in the application, that we will be able to get manufacturers to take all of that sound power away and give us pieces of equipment that will make the model work, it won't. And when it doesn't, at that point, the board has already given up the opportunity to say, you know what? This site is too small for this size substation. And all that will be left after the decision is to increase the height of the walls. But we already know from the testimony that the walls are about as high as you can go. If you went up an additional 5 feet on that westerly wall, you would accomplish 1 decibel reduction. I don't think that's going to be enough. In my opinion, the 8 decibels above ambient at my client's home is a myth. There's just no scientific basis to it whatsoever. And the evidence of that is contained right within the tentative decision.
Counselor, if you could.
Okay, I'll finish up. This constitutes an improper delegation of your authority and responsibility to a later time when your ultimate decision-making power has ceased to exist. There is case law that reads, a permit granting authority, which is what your board is in this case, may not delegate to another board or reserve to itself for future decision the determination of an issue of substance, i.e., one central to the matter before the permit granting authority. I think an issue central to this process is whether this substation fits on this site. Now, that case law comes out of my field. This is the first time I've ever appeared before this board. I practice locally. I spend all of my time in front of planning boards and zoning boards of appeals and conservation commissions. And this standard applies there. This is the Tebow case, Tebow versus Shrewsbury.
Familiar with the case.
You're familiar with Tebow, okay. I don't know, honestly, the extent to which our zoning principles apply to what you do here. I do know you have to have substantial evidence, and I am concerned that you don't because of these further reductions, which I think have not been explained in the least. I'll wrap up, I can tell.
Thank you.
Yes, okay. I'll just discuss your standard. Substantial evidence means such evidence as a reasonable mind might accept as adequate to support a conclusion. Well, that's about as helpful as the reasonable person standard in tort law. It's just an invitation for us to disagree, but you do have case law from your decisions that is helpful. You have one case that I found, Fitchburg Gas and Electric versus Department of Public Utilities, where there was a good discussion of what isn't substantial evidence. Both the board, your board, and the court found that there wasn't. The department determined that without the information, it was impossible to verify Dickerson's ability to achieve the schedule he had developed, that the establishment of a schedule without a greater level of supporting detail generated questions as to whether the schedule represented a realistic evaluation of the remaining work, and stated that the petitioners had presented unreviewable assertions that achievement of certain milestones was attainable. That's what you have here. You have unreviewable assertions that the achievement, the DEP noise policy limit, is attainable. I think that's a problem. And I think, you know, Jacqueline Johnson, who's here in the room with me, is one woman who lives in one house. But your credibility is important. The Commonwealth depends on communities and neighborhoods accepting that when you make a difficult decision of where should an energy facility go, it will be based on substantial evidence. And there are thousands of other Jackie Johnsons who live near parcels who may become the subject in the future of siting board decisions. And I think,
not only will this damage my client if the tentative decision is approved, but it would damage the credibility of this board. And that is critical to our communities and neighborhoods accepting the decisions that you make. And what makes it all work is that you base your decision on credible, substantial evidence, and it's missing here. Thank you very much.
Thank you. Does anybody on the board have a question? I just have one question, sir. I don't remember whether in the record, did you and or your client have another proposed site that would work for the substation that would have less impact?
We did not. 4 sites were examined, including a site right next door at 8 Shoot Flying Hill Road, which is owned by Mass DOT. And the company contacted Mass DOT. This is an 8-acre site. It's larger and has no residential abutters and has land around it that is preserved. So no residential abutters will come to that site. If this substation could go there, it wouldn't involve rerouting lines very much at all because it's right next door.
But there was, am I right that there was no noise analysis done on the other sites?
I do not know.
Okay. Okay.
But I do know that Mass DOT did not say, no, we're going to put a bus station there. You can't have it. All they said to the company was you would have to go through a public procurement process. And because this site was already under contract, this one was considered more desirable. But as I read the tentative decision and the analysis of those 4 sites, the other 3 is in the tentative decision, there's nothing wrong with that site. It's available. It's right there. It is wooded, which would mean cutting down more trees than here because here you have a motel and that would be a detriment. But in balancing this, I think that site would be far superior to this one because look at what's been done to try to make this 6-acre site work. The 35-foot.
No, I understand what you're saying. I just wanted to understand what the analysis was done on the other sites.
I didn't sponsor it. My client didn't do that,
Fair
but
enough.
we do see it in the decision.
Thank you. Okay, I think we have one more intervener. For Mark Ackerson. Oh,
Axelson.
Ackelson. Is there somebody on line? Is this lawyer online?
I believe the counselor from Mr. Axelson said they would vote not to be present.
Okay.
Or Mr. Eugenia.
Okay, thank you. We did receive written comments from them though. Okay, thank you. Yeah. Would the company like to respond to the noise issue?
Hello, Secretary Tepper, members of the board, Aaron Lang again. I'll be brief. I want to just address a few points that Mr. Sini raised in his comments. First off, the company does take Ms. Johnson's concerns very seriously, and that's reflected, I think, in the very thorough and comprehensive noise assessment that we did for the substation as part of the project. On the Mass DEP noise policy, it is not our position that we do not have to comply with that. We had said in briefing that the Mass DEP noise policy serves as a reference to the siting board, but that the siting board's inquiry is slightly different. And on the point of substantial evidence, I think that is also a little bit different than the standard of review that the siting board applies in these proceedings. But that is to say, we think we do have, the record shows substantial evidence to meet all of the requirements that the siting board has for its standard.
So what do you think the standard of review that we should be looking at is?
I think the standard of review is the 5-part standard that the siting board typically applies, summarized briefly, mitigating environmental impacts, ensuring that the route is clearly superior, and then approving the project on the basis of the record. I want to just address briefly the topic of the noise reductions and the fact that they're, according to Mr. Sini, is not evidence in the record. I would suggest that the opposite is true. Park City Wind engaged Epsilon and their sound experts who performed this study, who have decades of experience doing these types of studies using information that is typically accepted by the siting board in its proceedings. The reductions were made based on their experience, expertise, and technical judgment. And if I could, I'd read just quickly what they said in the record. They say, this is in response to one of the questions. What I've seen in my experience is that we calculate the sound power levels, using this information in this stage of permitting. And then later on, when the actual transformer has been specified and purchased, the manufacturers are coming in with sound levels that are generally quieter than what we assumed in permitting, sometimes several decibels quieter. There was testimony in the record to this effect, and it suggests that the experts that prepared the sound analysis did so based on their judgment. And they did so with the goal of acquiring acquiring substation equipment that is the quietest possible. There's been a lot of talk of an iterative process. To me, that sounds like a standard practice for designing substation site, optimizing the substation site, and ensuring that the best possible equipment is procured. But I think the key point here is to remember that the siting board has imposed in its tentative decision condition R. Condition R, as I mentioned, goes beyond what is typically required and will require the company to file pre-construction confirmation of the sound power levels for the specific pieces of substation equipment that will be acquired. And then will be backed up by further monitoring and a second compliance filing after the project becomes operational.
Can I just ask a quick question about that? So if the testing before the construction comes out that says it actually is higher than you thought it was going to be, I understand that your argument is that we're going to have a equipment that's specifically developed in order to meet the requirements of the site and in order to get to below 8 dBA. But let's say that doesn't happen. What options would the company have at that point to be able to reduce the emissions, the sound noise more?
Yeah, so I believe that's also covered in condition R, that's what the second part of the condition R pre-construction compliance filing will go to address. That the company will evaluate the information that it comes in, and if it does exceed levels, it will develop mitigation to address those in conjunction with the site board.
From a technical standpoint, you think that there are additional options?
From a technical standpoint, I think there would likely be additional options. I would have to defer to the technical experts on what those options might be, but
and then what's our remedy if that you don't have options that work?
Well, I think the remedy would be, well, if we don't have options that work. So I think well, first, the type of compliance filing that the siting board requires, these are typical submissions that the siting board typically addresses. I think the remedy is then to possibly proceed with a notice of project change or some other additional submission that would address the situation.
You mentioned Epsilon is on the line, right? Could we hear from them about what additional technical measures could be taken?
Epsilon is on the line. I believe our noise expert, Clint Sear, is joining remotely.
Give me 1 second.
Sure.
Thank you.
Should be joining the panel in a minute. Okay, Mr. Sear is in the panel. Mr. Sear, can you turn on your microphone and camera?
Good afternoon. Can you hear me?
We can, thank you. So, Mr. Sear, did you hear the question?
Yes. I believe the question was, what other technical responses might there be or options for mitigation, assuming the manufacturer's data comes in less than ideal or not quite as specified? Is that correct?
Correct.
So I think there was some mention of sound barriers. The model that was incorporated has barriers throughout the site, including 3-sided walls around specific equipment, around the stack comms, particularly on the west side. Those walls are relatively tall. there was some testing for, or sensitivity testing for additional height, really of one wall in particular on that west side. And I think that was where the smaller margin might be realized. However, there are other walls in the site that could be raised. I'm not sure that those, don't quite recall whether those were tested for additional heights. But another option is to utilize absorptive type barriers instead of reflective. The modeling that was implemented assumed that the walls were reflective, so you're going to have additional sound bouncing around in the site. If you absorb that sound on the walls, that's going to help to reduce the sound that's experienced in the community. So those are a couple different options.
Thank you.
Okay, thank you.
Thank you very much.
All right, I think we are up to public comments, members of the public. So we're now going to listen to comments from the public. As of today, I just want, for the record, for everyone to know that we have received written comments from over 400 individuals and groups, many in opposition to the project, but some in support. These comments have been posted in the Siting Board file room and are part of the official docket and have been provided to the board. So I do want to thank everyone who took the time to send us your comments. Appreciate the fact that people are focused on this and serious about it. And I personally received, I think, most of the comments. Had to make a special file for it on my computer, but I did look at them. So as I mentioned earlier, we are going to have to, in the interest of time, have public commenters be limited to 3 minutes. So we will gently remind you, but we would like to hear from as many commenters today as possible. And you really could help us do that by indicating your support for arguments that have already been presented, but not necessarily repeating them in detail. So let's start with
Okay,
that.
our first commenter is Suzanne Conley, who I believe has joined us in the panel.
Thank you, Ms. Conley. You may proceed.
Thank you so much. Members of the board and participants in this hearing, good day. My name is Suzanne Conley. I'm a resident of Osterville Village. Because of the work I have done for over a year in opposition to a similar but larger project by Avangrid for the town of Barnstable, my knowledge and understanding of electrical generation and transmission is at a level I never would have imagined. I only have 2 general comments on the matter before you today, the TD. First, the board's tentative decision to approve the Park City Wind project gives no discernible consideration to the extent of public opposition to this project by Barnstable residents. For reasons that are not frivolous, this opposition, and that have been expressed by so many individuals. It is not enough to rely on the company's testimony that they have, quote, engaged the community and interpret that engagement as acquiescence. In fact, the opposite is quite true. I can't recollect if the board held a public hearing in the community as the EFSB website indicates to be standard practice. You would have heard firsthand questions about the safety of high voltage cables and splicing vaults under a recreational beach through our residential neighborhoods and over our wellhead protection zones. You would have heard concerns about deleterious thermal effects from high voltage conductors on water mains. You would have heard outrage about the location of and danger posed by a substation built over a shallow aquifer and next to a neighborhood. I do want to point out, to follow Mr. Senni's comments, that this small site requires the company to build with very, very volatile and dangerous dielectric gas. It's sulfur hexafluoride, SF6, instead of air cooling dielectric. I think that's one of the problems with the substations here. I wonder if such an experience in the community would have resulted in a decision less obviously tilted in every respect to the company's favor. Frankly, the suggestion in the tentative decision that the company and the town discuss posting signs on Craigville Beach, warning the public of high voltage buried cables, indicates to me that the board might share at least some measure of concern about the wisdom of the cable landing site as well. My main point, though, is that I see a pattern throughout the document. The company makes general, mostly unsupported assurances that every aspect of their project is safe, that no harm will befall people, the environment, wildlife, and businesses, and the board responds that mitigation is deemed adequate. Which brings me to my second point. With so much at stake with respect to the environment in Barnstable, I believe independent evaluation of environmental risk is called for before any final decision on the Park City Wind project is made. I find unacceptable any statement that this by the board that this facility be constructed promptly. I would ask, what's the hurry? But no, the answer is tied to policy deadlines. I respectfully ask the board to set aside such considerations in the interest of protecting our community from a project motivated only by ease, speed, and corporate profit. I'd like to thank Mr. Watson for asking about the extent of public involvement in the creation of the HCA. There basically was none. So that's the answer to your question, sir. And finally, I just want to mention that Foley Hoag's helpful list of errata missed a reference on page 110 to a duck bank, DUCK, which should be corrected in the final version of the TD. Thank you very much for hearing me out. I really appreciate the board's willingness to do so. Thank you.
Thank you very much for your comments.
Our next pre-registered commenter is Carol Lampson. Mr. Wong, is she moving to the panel?
She's in the panel.
Hello, I'm afraid I'm on a laptop that doesn't have a camera and I apologize. Thank you for the ability to comment on this project. I am strongly in favor of it. I hope that the board approves the project as proposed today. Living on Cape Cod, I'm very concerned about the effects of climate change, including saltwater intrusion into our Soul aquifer. And I am perplexed why people who oppose this project think that they're protecting beaches when we all know that rapid ice melt from global warming associated with climate change threatens to swamp every beach in the world, including those on Cape Cod. I think the project makes sense the way that it has been put forward. Everything I listened to today only confirms that judgment. And I hope that it seems the most efficient and effective way to land the cable where it's proposed. Everything I heard about the noise on the substation doesn't make sense to me since I live on Cape Cod and I know what the traffic noise is down Shoot Flying Hill Road, and the wind almost never stops. So I am puzzled why we think anyone will hear that substation above the ambient noise that's always on Cape Cod. I hope that you approve the project as submitted. Thank you so much.
Thank you, ma'am.
Our next commenter is George Backrack.
I don't see him in the panel.
He's here.
Oh.
Hello, Mr. Backrack. Good to see you.
I hope I haven't exhausted my 3 minutes by walking up here.
We'll give you the
The
extra
clock
time.
just started. I'm a little slow. Thank you, Madam Secretary and members of the board. My name is George Backrack, and I have spent an earlier 10 years of my life as the president of the Environmental League of Massachusetts. And more importantly, for the last 40 years, I've had a home in Barnstable and have spent with my family growing up on the beaches of Dowsers, Craigville, Cowes. And I am strong in support of this project moving forward. I have a great concern about the representation that the citizens of Barnstable are opposed to this project. There's a small group of naysayers. They've been very effective in getting a petition circulated with the heading "Save the Beach." I can't imagine anybody not signing that petition, "Save the Beach." And it also has a wonderful picture of a pristine beach that apparently is being saved. And the reality is that pristine picture of the beach is the picture of before, during, and after. Not a grain of sand is going to be touched on these beaches. Not a puffin is going to be disturbed, despite what you hear on these beaches.
the world of Barnstable will not be disrupted by the running of transmission lines. In fact, in many instances, it will save the town of Barnstable money as they dig their sewer lines at the same time as these transmission lines are also laid. I'm appalled by the presumption of some people to speak for others, when in fact, so many of us in the town support this project. I would close with a vision, which I think is inevitable for the future of the Commonwealth and the country, which is along our eastern seaboard, there will be a white picket fence. And that white picket fence will be deep water offshore wind turbines that will provide the energy this country needs and the national security this country needs. And the sooner we get there, the better. One last point, again, all these public health issues about electromagnetic fields. One of the problems we have with the NIMBY world is that they will find somewhere on the internet, a wonderful tool, the internet, some outlying scientific study that no one else in the scientific world agrees with, and they will bring it forward as though it's the Bible. So I rely upon you to look at the real science and to support this project. Thank you.
Thank you, Mr. Becker.
Okay, our next commenter, I believe who is remote, is Robert Schulte.
Good morning, EFSB members. Thank you for the opportunity to speak today. My name is Bob Schulte and I'm a resident of Centerville. First, while I understand the limitations that COVID placed on in-person hearings over the past few years, I believe this hearing should have been held in person at the Cape Cod Community College, just like your November 14th hearing on the proposed Mid-Cape Reliability Project. Until today, there has been no in-person public hearing held by the EFSB on the Cape for the Park City Wind Project. That is a failure by the EFSB to fulfill its responsibility to seek input from the members of the public most impacted by this project. Second, the EFSB is convening today to render a decision on the Park City Wind Project without full knowledge or consideration of the dire threats that this project and its proposed massive new substation poses to the Cape Cod sole source aquifer. That aquifer is the only source of drinking water on the Cape. The town and the public learned last Friday night at 5:48 p.m., essentially 2 business hours before this hearing started this morning at 9:30 a.m., that Park City Wind is planning to use 125,000 gallons of toxic dielectric fluids at the proposed substation located on Shootflying Hill Road. Again, this proposed substation would be located directly on top of Cape Cod's sole source aquifer, which provides all of the drinking water to a majority of the Cape's approximately 230,000 year-round residents and over 500,000 summertime residents. The 125,000 gallons is over 3 times the 39,000 gallons currently used at Eversource's Oak Street substation, and almost twice the 69,000 gallons that are proposed for the Oak Street expansion project. Using the EFSB's own terminology from its decision on Cape Wind, this last-minute revelation of the extremely large amounts of toxic dielectric fluids at the proposed substation qualifies as a significant change in the background conditions, including the potential environmental impacts of this project. The last-minute disclosure of such critical information should, in itself, be enough reason for the EFSB to deny or at least postpone this decision and require a supplemental environmental impact statement for the project. However, the fact that this proposed substation and its 125,000 gallons of toxic fluids will lie directly on top of Cape Cod's sole source aquifer screams out for the EFSB to pause the process until more information can be obtained and considered before any decision is rendered. At the EFSB's November 14th hearing, Barnstable Town Attorney Charles McLaughlin told the EFB members present, several of which include those of you who are here today, that several years ago there was an industrial accident which involved the spill of 8 gallons of cleaning solvent at the Cape Cod potato chip factory. That spill ended up shutting down several of Barnstable's water district's wellheads for the better part of 8 years. One can only imagine what the impact would be if there was a fire or transformer explosion at the substation that resulted in hundreds, much less thousands of gallons of toxic dielectric fluids leaking into the Cape's sole source aquifer, and compromising the drinking water of towns from one end of the Cape to the other.
Sir, could
Don't
you,
any of you see?
please? You finish
Excuse
up,
me?
please? Can you finish
yeah.
up, please?
Yes,
Thank you.
yes. Don't any of you see the risk this project poses to the health and safety and financial well-being of the Cape's year-round and summertime residents, as well as its tourism-based economy? Given your long and strong record of service in protecting our environment, I, as a fellow citizen who is also concerned with preserving our environment, appeal to you to delay any decision on the Park City Wind project until the siting board can review all of the facts in this case, including those that have been just disclosed in the last 24 business hours. Please, please do the right thing and either reject or postpone any decision on this project. Thank you for the opportunity to speak.
Thank you, sir.
Next up is Nancy Grella.
Okay. So there's no Nancy Gralla in the attendees, but there's an Andrew Gralla. If Nancy, you're using a different account, could you raise your hand on that account, please?
Let's move Andrew Grella to the panel and find out if that is in fact Nancy. Oops. We may have not moved Nancy or Andrew Grella.
We can come back to
Okay.
that.
All right, if we miss you, please raise your hand by dialing *9 on, or I'm sorry, raising your hand on the Zoom screen, or *9 if you're on a phone. The next commenter who pre-registered is Cliff Carroll. Okay, Mr. Carroll is in the panel. Mr. Carroll, your microphone is muted.
Am I out there now?
You are.
Okay, thank you very much. And Craig Watson, it's good to see you. I don't think I've seen you in about 10 years since Cape Wind. A couple of different things, and I'll try and make this as quickly as possible. As Attorney Senni pointed out, even though the state of Massachusetts has given the EFSB this incredible power to override local and critical and life-saving zoning regulations, it does not give the EFSB the right to recklessly put the lives, welfare, and future health of the citizens of Cape Cod at risk to meet renewable energy goals. With that being said, and again, I'm going to talk very quickly. I'm reacting to the comments here. Mr. Kimmel stated that he wishes the town could have worked with him. They also stated that they have done open houses and neighborhood meetings all over the Cape. That's true. And about 95% of the people that attend those meetings walk out of there horrified by the project. The Cape Cod Commission did render a decision. If you look closely at that determination, Avangrid withheld the information about the transformer substation, which we learned about it after hours on Friday night. In the 11/22 EFSB decision, the 125,000 gallons wasn't even disclosed in that determination. We learned about this Friday night on the eve of this hearing. Basically, it's the equivalent of the same day. In addition to that, there's going to be 45,000 pounds of SF6 gas pointed out by Mrs. O'Connor earlier here in the testimony. On the EPA's own website, it states that that is the worst greenhouse gas, and actually it is the most potent greenhouse gas known to date. This is quotes from the EPA. Over a 100-year period, SF6 gas is 23,500 times more effective at trapping infrared radiation than in the equivalent amount of carbon gas. The reason they're doing this, in addition to the 125,000 gallons, is pretty much almost to ensure that when this thing catches on fire, that we'll be looking at a potential absolute disaster. I'm going to play a short 15-second video and then I'll come right back to you. That is an electric transformer substation in Madison, New York that blew up last February. And basically, that is what they're putting on top of one of the highest points of land in the center of our sole source aquifer in the town of Barnstable's aquifer protection zones.
Sir, if you could finish up, please.
I'm sorry, ma'am?
You're at time. If you could finish up, please.
I will. The reason this has not been discussed or dealt with properly over the past 3 years is that Avangrid has intentionally withheld this information until last Friday night. There's no way the town of Barnstable or anybody else could have anticipated the devastation that this transformer substation places in the middle of our sole source aquifer, which is the equivalent of the Quabbin Reservoir to the supplying of water to Boston. It's just that ours is underground and it's directly underneath this location. Thank you very much for your time.
Thank you.
Your next commenter, Wayne. Raymond Brooks.
He's not accepted the.
He's not accepting the. Okay, then we'll move on to our next commenters. Sandy Fitzgerald.
That person's not in the attendee list.
Okay, I'm gonna give a shout out to, again, Sandy Fitzgerald. If you are here, please raise your hand. And nobody else if you're not Sandy Fitzgerald. Okay, got a lot of hand raisers, but not Sandy Fitzgerald. It's not Sandy Jones.
You gonna try that?
Why don't you try Sandy Jones? Just a hunch. Yay or nay?
They've accepted.
Okay. Okay, Sandy Jones, you're in the panel. Could you turn on your microphone and camera, please?
Yes, can you hear me?
Yes.
Yes, okay. Thank you for allowing me to speak today. My name is Sandy Jones. And I oppose this project and I ask the board to potentially delay your decision. The reason being is up until recently, the residents of Barnstable were not in talks with the town management. We put together a petition. We had an open meeting the end of October, which Avangrid attended. Then it followed up. There was on November 14th, there was an Eversource hearing regarding the proposal of the expansion over at 661 Oak Street. At that time, there were over 700 people in the room and many of the panels on your board, they attended the meeting and they listened to the concerns. When the gentleman spoke from Barnstable that there are residents that are more so in favor of the project, that is not true. We now have a working group. We meet with our town manager and we discuss the status. As far as when Mr. Wilson asked where the public was during the negotiations and conversations, we never had that opportunity. Our town as a town council, we're allowed to speak for 3 minutes and that's it. And so it wasn't until, again, over the last 4 weeks, we've been allowed to speak with our town and find out what's going on. The reason why I oppose this project is, first of all, is the proposed route tunneling under the Centerville River. Our conservation department did approve it, but they did not approve monitoring down the onshore route. This project, nobody's mentioning this, we are a pass-through town. The project does not benefit the state of Massachusetts. It's not for the welfare of the general public. As Mr. Kimmel spoke today and stated he wants to advance Massachusetts offshore agenda. This project is named Park City Wind because the project is going to Bridgeport, Connecticut. The size of this substation over at 8 Shoot Flying Hill Road, it's a large amount of oil. I watched the evidentiary hearings back in July of 2021. The FSB board specifically asked, what is the size of this? And given what you are proposing, how big is this? And the room went silent. They couldn't answer the containment and how large, and they took it as a record request. 8 Shoot Flying Hill Road is directly above a working cranberry bog, which empties into Lake Woquacket. The area is not it's a residential neighborhood. And as far as the sounds for 82 Shoot Flying Hill Road, Vineyard Wind has the exact same wattage, 800 megawatts. And it was disclosed that it's going to be up and running with 5 wind turbines by December 31st. It's over in Independence Park. Why could they not monitor the decibels at that point? It's only 5 wind turbines. Why could that not be used to help? And why can't this hearing be postponed or decision be postponed until we have all the information available?
Thank you. Appreciate your comments.
Okay, I'm at 3 minutes.
Over.
You are.
Thank you.
All right, we have a few more comments that pre-registered, so we're going to keep going with Alan's indulgence. The next commenter is Stephen Smith. Is Mr. Smith in the panel?
Good afternoon. Can you hear me?
We can. Thank you.
Thank you. I'm speaking on behalf of the Cape Cod Technology Council Incorporated on the tentative decision of the Energy Facility Siting Board on the Park City Wind project. Founded in 1996, the Cape Cod Technology Council is a membership-based nonprofit organization whose mission is to promote technology, education, and economic development on the Cape, the islands, and southeastern Massachusetts. Our membership includes local Cape, Islands, and southeastern Massachusetts businesses, technology innovators, educational organizations, government entities, working professionals, and community leaders. The Tech Council supports the development of innovative solutions to meet the anticipated energy needs of the Commonwealth of Massachusetts. One of the most promising of these solutions is wind energy. In light of the long-term energy and climate benefits offered by offshore wind projects such as Park City Wind, the Tech Council has consistently urged that regulatory bodies carefully review and appropriately act on the offshore wind proposals. Having reviewed the tentative decision of the EFSB, it is apparent to the Council that the EFSB has conducted a comprehensive review and reached an appropriate conclusion. Thank you very much.
Thank you.
Okay, our next commenter is Chuck Tuttle. Mr.
Hello.
Tuttle.
Good afternoon. Hello.
We can hear
You may proceed, sir.
Great. Thank you. Good afternoon. Thank you for the opportunity. And thank you, EFSB, for your diligent efforts. I've got to respond to a previous public commenter comment that said that the the folks that are adamantly opposed to this diabolical project are a small group. On October 23rd, we had a public hearing with almost 1,000 citizens attending in person and online. I don't think there has ever been a meeting in the town of Barnstable with 1,000 people on one topic. So that gentleman is certainly in error. There are thousands of people in the town that can't believe this project has gotten this far. It's not NIMBY. I don't want this project in anybody's backyard. This is not appropriate to put 2 billion watts of power through recreational areas and residential areas when other more appropriate industrial sites are available. In response to that comment, Avangrid said, well, you know, it's been done in France. Well, okay, let's have a look at Saint Nazaire, a landfall for wind power in France. Saint Nazaire is an industrial shipbuilding city, a far cry from the quiet recreation enjoyed at the beaches on Cape Cod. The electrical transmission cables in France and other European nations come ashore at industrial ports, not recreational and residential areas. And now we've got, you know, quote, thorough testing. Sound tests show that Avangrid is cheating. They're reducing the sound output to meet the approved decibel levels. And then on Friday, they announced that they're going to use 120,000 gallons of dielectric fluid. It's just crazy. I think that the EFSB owes it to the Commonwealth of Massachusetts and the citizens of the county of Barnstable to get all the facts before they make a decision. Obviously, one of the facts was announced Friday after work, 120,000 gallons of toxic fluid above our single source aquifer. I know you folks need to, quote, rapidly deploy, but at what cost? What about our drinking water? I don't understand. What about the humans? Can't we please slow this down so that we can have some input and do this correctly? 2 billion watts of power does not need to come ashore at our recreational and residential areas. Thank you very much for the opportunity.
Thank you.
Okay, our next speaker is Rosemary Carey.
She declined.
Okay. Next is Edward Kirk. Mr. Kirk?
Go ahead, Mr. Kirk.
Your microphone is muted.
Yes, I see that. Am I,
We can hear you now.
you can hear me? All
We
right, thank, I guess, I have a camera on my, computer, but I would like to be able to use that, but, let's see. Okay, all right.
We
I
can
have a
see you,
face,
sir.
I have a face made for radio, but I thought I'd take a chance here. I live, my name is Ed Kirk. I live at Hillside Drive, which is just off Shoe Flying Hill Road. And I sent a letter to the board on December 6th, and I followed it up with an email this morning because, as other folks have said, we just learned Friday evening that this question of 125,000 gallons of dielectric fluid will be on site at the substation. I don't know anything about dielectric fluid and what its consequences might be if it's released in some fashion. And so that's why I have asked that the board delay this particular decision for 45 days to allow 10 residents, as are allowed under your regulations, to intervene as parties or as a group in these proceedings to bring to the board's attention information relating to the 125,000 gallons. And as has also been pointed out, this substation is located directly, almost adjacent to the 15-acre active cranberry bog, which leads directly into Lake Wequacket, which then leads directly to Long Pond on the other side. of Route 28. And so that's an environmental issue. And I was very surprised when, like a lot of other people, we found out about this project and sort of belatedly trying to run and catch up to the train here, that in the plans relating to the substation, there was no demonstration that there was a wetland, a cranberry bog right nearby. I don't really understand how that got left out. But I think now that you folks know that there's a bog there, and I've attached to my letter some of the town assessors maps that show the bog and its proximity to the lake, that you will look favorably upon a request to delay this so that this issue can be explored. I think it's only fair, frankly, that you do that, and I think it would reflect well on your board's determination to get all the facts before you make a decision. I also want to be on record as saying that I don't believe this project qualifies under General Laws, Chapter 48, Section 3, for the exemption they're requesting. They are not a public service corporation in Massachusetts. They are an offshore group of investors incorporated in the state of Delaware. Their only connection with the state of Massachusetts is a piece of paper filed with the Secretary of State.
Sir, if you could wrap up, please. Thank you.
Yes. And what they're seeking to do is find the cheapest way to get from offshore to the state of Connecticut. And they find our beaches and our roads and our land and our residential districts are the shortest way to get there. I think you should deny or look more carefully at whether or not they are in fact a public service corporation whose purpose is to serve the welfare of the Commonwealth of Massachusetts. So, thank you for your
comments, sir.
consideration.
Thank you.
Okay, next commenter, Ellen Nozel.
I'm here. Can you see me?
We can hear
Your
you.
camera is not on,
Okay. Hold on just a moment, please.
but we can hear you.
Just let me try that one more time. Okay, that's it. Thank you. Before my 3 minutes are calculated, I should like to point out that at least at the beginning of this hearing, there were hundreds of people in the area whose power was knocked out by our typically severe weather conditions here on the Cape. At least 800 people in the town of Barnstable, in the town of Bourne, who may not be able to participate, who wished they could at this time. So please make a note of that. My name is Ellen Nozel. I live in Centerville. It is the job of the Energy Facility Siting Board to determine if a proposed energy project is appropriate for the site or location. In the case of Park City Wind, you may be allowing landfall on a public beach and thereby supersizing a substation on a wellhead adjacent to homes, a lake, and cranberry bogs. Entirely inappropriate locations. Let this board's decision serve as a warning to every open space, public beach, protected land, and neighborhood. Nothing and nowhere is sacred. Hundreds of citizens, not a handful of naysayers, have provided oral and written comments to this proposed project because the state of Massachusetts has done nothing to protect us. It issued clean energy mandates and timelines without parameters that might have protected us from the situation in which we find ourselves now. A multinational, multi-billion-dollar corporation drew the shortest line between the leased area in Vineyard Sound and land and put 3 bullseyes in Centerville Harbor. Had the state required that multi-megawatt energy developments come ashore in industrialized areas with an infrastructure that can support them, we would not be alone here in our dedication to protecting our fragile peninsula, its land, water, animals, and human beings. Does the Park City Wind proposed project, with its plan to provide energy credits to Bridgeport, Connecticut, even advance Massachusetts clean energy mandates? It appeared under the cover of darkness in a world pandemic. Barnstable citizens knew nothing about offshore wind projects until heavy equipment closed Covell's beach. In the ensuing years, the true colors of Avangrid and the realities facing Barnstable slowly came to light, in a large part by the research and persistence of its citizens. Common sense and common courtesy would have allowed for Barnstable's application to be an intervener in this case. This board can choose to dismiss or ignore truth, but we will continue to expose it. As Mr. Tuttle said, this is not a question of my backyard. Cape Cod is Massachusetts' backyard. It's America's backyard. We share our backyard with every visitor. You are probably among them. We all swim in the same ocean, sit on the same beaches, drink the same water, and drive down the same streets. And most importantly, we are in the backyard of protected species whose habitat is at risk year-round. Think about hundreds of megawatts of electricity the next time you dig your toes in the sand. Park City Wind.
Wrap up, please.
You
Could you
bet.
wrap up? Thank you.
Yes. Park City Wind still has a long way to go before any blades begin turning, if ever. In the meantime, we will continue to demand protections and transparency, as well as communications and proceedings that are not always at the 11th hour. If the state of Massachusetts had had a clear, intelligent vision for developing renewable energy, we would not be seeing it all through the eyes of a for-profit corporation that has been given the keys to Massachusetts. Thank you for your time.
Thank you, ma'am.
Next is Heather Swenson.
I am here.
We can hear you and see you.
Okay, thank you. My name is Heather Swenson. I live in Centerville. Living on Lake Wapquacket, we follow strict guidelines of the town and state for protecting our waterways, wetlands, great ponds, lakes. Cutting down trees, fertilizing, septic system maintenance, general maintenance of your yard, all have strict guidelines for those living near the water. In the time that I've lived here on the Cape, all we hear is protect our water. We need to protect our drinking water, our waterways, great ponds, lakes, oceans from potential hazards and pollutants. And yet now it is being considered to put a power substation containing 125,000 gallons of dielectric oils right near what we want to protect the most. It is beyond comprehensive how the town, state, and engineers have disregarded this proximity. Up until this point, the town of Barnstable council members have made these decisions and agreements without input from taxpayers that will be affected. There has not been an option for taxpayers to vote on a decision about the project. I want to point out that these hearings for wind power projects began during COVID shutdowns. Many hearings were done with no public participation. I believe that was not due to the lack of interest. It was due to lack of knowledge it was even taking place. Of late, many of the project company and EFSB postings in the meetings have taken place during holiday timeframes, just before Thanksgiving, this being during Christmas, leading up to Christmas week. Since becoming aware of the magnitude of this project, I have tried to read, research, and obtain as much information as possible. In reviewing OSHA safety data sheets, one relating to transformer oil used as an insulating oil, it lists under ecological information as an identification of H4112, hazardous to aquatic environment, chronic toxicity. Under section 2, hazard identification, it's listed with a label element of danger. Under toxicity, it states harmful to aquatic life with long-lasting effects. Toxicity, harmful to aquatic organisms, making long-term adverse effects to aquatic environment. In an OSHA data sheet relating to the type of dielectric fluid, under firefighting measures, it states unsuitable extinguishment for media. Do not use water as an extinguisher. Under specific hazards during firefighting, it states thermal decomposition can lead to the release of irritating gases and vapors. So when at the November meeting, an engineer stood up and told us they would not recommend a fire department use water. They would instead be requested to just allow the fire to burn out. This would be exposing residents to known irritating gases and vapors. In the same safety data sheet under environmental precautions, it specifically states should not be released into the environment, prevent from reaching drains, sewers, and waterways. I would ask, has Park City Wind or Eversource provided information on exactly what type of fluids are going to be at this site? And has the EFSB reviewed OSHA safety data sheets on what is proposed? In a 2009,
Wrap up, please. Thank you.
Okay. There are other locations for the project at this type and size. It does not belong in a residential area. All the studies and information given today do not address how does this project affect daily life of those near the substation. It's not just about what if during a catastrophic event. It's about the lifestyle effects on each of these residents. If you're not concerned about the citizens living in the area or near this proposed project, please consider the wildlife. I recently sent an email to most all of you. It was pictures taken from my home: bald eagles, ospreys, red-tailed hawks, turkeys, otters, muskrats, coyotes, snapping turtles, largemouth bass, pickerel, northern pike, all call Wequaquet Lake and the surrounding area home.
Okay, ma'am, can you please wrap up?
Please consider the environment. Based on the information today, I urge you to allow more information be obtained and presented before making a decision. I thank Representative Exaros for speaking out, and I request Representative Diggs and Senator Sear get involved. Thank you.
Thank you.
Okay, we are at our last pre-registered public commenter.
He's not here.
Mr. Moriarty, not here?
Not in the attendee list.
Hold on one second. Mr. Moriarty, if you are here, please raise your hand, and only Mr. Moriarty, please. You are correct, Mr. Wong. So we have
I think we
completed all
will.
pre-registered speakers.
I think we'll take a break right now. It is 1 o'clock. So we'll take another 10-minute break. Thank you.
And there's two and a half hours.
Stick on my butt.
And feel free to help yourself. There's still snacks, I think. They haven't all gone away.
You should have told me. I should have been in Stones.
I know, well.
I don't think there was enough snacks for me after what you did. After what you did, there was not enough snacks for me.
Maybe it's better over here by the window. I've got two bars. Yeah, you're right. You're absolutely right. Anyway, well, I gotta go. Get something to eat.
Great, yeah, I'm a resident and I work with Paul on a number of projects over the years, great, and solar projects along that way. Candy Green. Yeah. Remember Paul, that's it's simulation. Many years ago, I put that one in the back of my head for sure case. Congratulations. Great guy. I don't know. I'm deeply grateful. He has. He's been. Boy, I don't know when they recruited him, but it's been a while. What do you do? Well, that's senior staff person. Oh, that's fine. That's why I'm sitting over there. Earlier time. Effective off. Security, era. Yeah. It wasn't different. I've seen it better. That makes it sound a long time ago, but. I'll let you learn. I'm on your way. Okay, very carefully.
Okay, have to. I was I went with my daughter to somewhat holiday market yesterday. Recently had everything, right? Because you don't think of it. Like this. But yeah. Are you actually in we are in this building? Yeah, right now. We switched. We're a nine.
No, I mean, I just wanted to make sure that.
And
So
before we were we were so we were, I don't know. Well,
right on.
Yes, really liked it.
Oh, I'm sure.
You know, there you go. You've been renovated, you go back and what used to be. Same thing, South Station, and they found renovated, we're both of the fluids down at South Station. I've seen three. And it's great. Wow. Once it does, it'll be good. Yeah, no, they are. They're nice and clean and bright. And the space is well. So, you know, yeah, I have an office. I mean, we have four. We have one office for the really close to the night in there. And comes in here. But how often you guys in? Yeah, been, do I come in? Some people come in. We have a minute here. I mean, I. I know. I just got a Zoom. It's a booster thing? No. Oh, me and you, that's scary. Yes, and so we used to like knock me off all the time. Unbelievable. Right? Yeah. Oh, you get rid of water. You were so good. I mean, so good. Yeah. That's right. Engineers are architects right now. Can't pay them. I think so. Yeah, because I had to that I had to go instead on. Exactly. And we got.
Yeah.
It is in the. That's nothing else. That's really your option. We're doing that. I'll think about that. It's usually, you know, for PC and I haven't been going the last week, so once it is. Right, I'm gonna start. No, we're gonna start with, motion. Yes, I just need to, check in on it. Yeah. I have tea. Where you? They kick it from. Okay. Okay. It's no reminder about the title.
Okay.
Everybody back?
So I hope you've all had a leisurely break. Thank you for coming back on time. And I think the first thing that we're going to do now is we're going to I'd like to hear from the lawyers on how we should proceed with respect to the motion that was filed this morning. Mr. McLaughlin, can you please give us your view on how we should proceed?
Yes, I appreciate the time and the opportunity. I'll be very brief. I would suggest to the broadest question, it would seem procedurally that in order for us to offer comments for your consideration, we need to be admitted as a party as I read the rules. And that is what prompted us, after reading the draft decision, to conclude that our time and your time is best spent considering what Town Manager Mark Ells has offered for commentary. And to do that, again, I think it would be appropriate. I'll be very brief in my comments about why a limited intervention, which is what we're seeking now, ought to be allowed. And if that is your wish.
Mr. McLaughlin, can I just ask you a quick question?
Sure.
Have you withdrawn your earlier motion? In other words,
we have not.
Is a motion on the table now the limited request for intervention?
That is correct.
So we no longer need to consider the first motion?
I will defer to you procedurally and to your staff, but I'm content if we just move to this matter, and we're seeking the very limited opportunity in this revised motion to offer comments only with respect to the draft decision and the amendments to the draft decision or tentative decision that are in front of you. And if we are allowed that opportunity, we would be content, and we would also be withdrawing on the allowance of that motion, would be withdrawing our petition to reopen the hearings.
Okay, understood. Mr. Khan. Can you please speak to the board's authority to consider the conditions and the comments of the town without granting the motion to intervene?
The board does not need to make the town a intervener of any kind in order to consider their comments. As we've seen, there have been hundreds of public comments, which the board is capable of reviewing and incorporating in any decision. And we don't object to the town filing comments. We do object to them being named as an intervener at literally the last moment. So I don't see any problem with the town making comments, including this morning's, which we've not had a chance to really read or digest, but they can make their comment.
So it's your view that we could look at the comments that were filed this morning and look at them on the merits and either adopt them or not adopt them, just as we would with any other comment?
As you would with any other comment.
Thank you. Do you have anything else you want to add?
I would just briefly remark that the matters that the town is seeking modifications of the tentative decision on, at least for the most part. And I have to say that I have not been able to review all of the changes because of when it was filed. But what the town is looking for, I think they already have through the host community agreement that the town manager Ells has expressed and Attorney McLaughlin has expressed, needs for more information or for more consultation regarding emergencies, regarding outreach, regarding construction, regarding traffic. The host community agreement already provides for all of that. And there are frequent communications. Just as one example, there's a meeting with the Department of Public Works, the Barnstable Public Works, scheduled for tomorrow, just to talk about construction and ensuring minimal interference in the town during construction. So we do think that to consultations with the town, we think that the HC already provides it. We think it's not necessary to include in this decision, especially because we haven't really had a chance to look at the specifics and don't at this point have a comment on the specifics they've proposed. We will talk with the town though in any event.
Would the town be willing to open up the host agreement for possible amendments based on the conversations that you have with the town?
Would we be able?
Would you be willing to do that?
At this point, we don't think the host community agreement needs to be amended, but if something needs to be amended, then it's not a difficult process to do that. So we'd have to see the specifics and consider that in a specific,
So you think that the terms of the agreement right now are broad enough to accommodate the request in general by the town?
to accommodate discussion of those requests. We may not agree with all the
Fair
specifics,
enough.
but to accommodate discussion, yes.
Okay, all right. Does anybody else want to be heard on this question? Board
May
members?
I?
Yep, please.
Madam Chair, if I could, and appreciate the opportunity to comment further. I guess obviously your board has enormous discretion, and it's acknowledged, and having been through the litigation with Cape Wind and having had lots of lessons taught to us by the SJC, there's no doubt that you have the discretion. But the question as to the resistance that I'm hearing as to why they do not want us as a participant, a intervener in this particular case, is concerning, because I haven't heard a single plausible reason as to what harm is to be accomplished or result from our being admitted as a intervener. I think it's important that our concerns are recognized as offered in good faith and having significant, impactful points that the board should be considering. And concomitant with that, there are lots of reasons why we got here. It's this particular position that doesn't serve any of us to go back through that right now. But I think the importance here is that there has not been a reason offered as to how somehow this project is going to be imperiled if it takes another 2 weeks to get this right, and give us everyone an opportunity, including the board, to have a chance to look through our suggested alternatives to the drafts that are in front of you, and then come back and vote on those. That having been said, I think the discretion that you would exercise in allowing us to come in would be fully supportable. I think it sets a good reaffirmance and frankly a reward to both parties and an encouragement to both parties to sit down and deal in good faith, and we've had a really excellent relationship working through some difficult questions. But as Town Manager Els has raised, I'm not going to repeat the specifics right now, but there are real issues of concern that have potential far-reaching impact, and not something that if they are going to be disputed, we ought to have an opportunity to go back and ask the board with extended argument on those to each of us suggesting why these changes should be adopted by the board. And I think, again, that's best accomplished on limiting our involvement and with our representation, that we will be addressing these comments only in the context of this matter that we have already offered, and we'd like to do so as an intervener. And to be able to come back to the board as an intervener if there is something of real significance that needs more attention. And more decision making by this board after hearing conflicting arguments. That would be my heading.
Thank you. So I'd like to hear the staff's view on this.
Well, I do have a question for Mr. McLaughlin and perhaps for the town manager as well, which is that there was an opportunity for parties in the case, and I realize Barnstable was waiting for an answer on that question, but also public commenters to submit as detailed comments on the TD as any individual wanted to provide. And we requested those comments from the public by last Wednesday, December 6th. And the town of Barnstable did take the opportunity to submit some comments that came in from, I believe, your colleague, Mr. LaRussa. And we did get some specific feedback on the TD, but by no means anywhere near the kind of detailed markup that you provided a few minutes before the board meeting started today, which puts all of us in a very difficult spot of trying to understand what the town is now looking for as specific amendments or modifications and process that. beyond the 11th hour, I'm going to say. So my question is, why didn't these specific recommendations come in on December 6th with the other comments that Barnstable provided from your department?
I think the answer is multifold. One is the obvious that we did not have the benefit of these amendments, which are significant, and particularly which we're addressing with consequences that could be important to us. The decision the recommended decision to deny intervention, period. So while we're doing that, we move forward and looking at other substantive matters in the amendments that we thought were deserving of further clarification. And as to my brother's observation to your question, sir, I would respectfully argue that, as some have argued to you in writing already, that the delivery time of this on a Friday evening, and having to assemble the crew and get everything together and provide these substantive comments that we hope would be helpful to the board in focusing on areas of concern that Manager Ellis has mentioned with the considerable detail. We have done the very best we can in a 48-hour turnaround over a weekend to provide those, and I don't think we should be labeled as in this case anything other than diligent in trying to bring the seriousness of our concerns with detail and accuracy to your attention. So the facts are the facts, the timing is the timing, and that's how we got here. Again, I don't intend to get into our non-participation. I will tell you, just as a quick throwaway, if you will, that
Mr. McLaughlin, I appreciate it. We don't have a lot of time, so could you just kind of sum up, please?
Sure. So I on that point, we are here, we're seeking limited intervention. I think procedurally, we would appreciate that. We have done everything we can to support the Mini Wind project. We've walked the walk, we've talked the talk. We've got people on the ground dealing with these issues every day, and I think they're worthy of your consideration. And we're prepared to address the substantive comments if and when you are ready to do so. But I think all of those, because of the seriousness of the concerns, everything from PFAS to containment to emergency response and the like, are matters that all argue strongly in favor of granting us the limited intervention status that we seek. I'm ready to address the merits if you want to move on to that. And when you're ready, I'll just withhold my comments for now.
Thank you. I do want to say, I think there is an assumption that everybody here is acting with best intentions. So didn't mean to imply otherwise.
Oh, no, please. I did not mean to suggest that. I know you know that.
John.
Briefly, on behalf.
Ms.
Thank
Evans,
you.
sorry.
Thank you. Briefly, on behalf of staff, as noted by other parties, I will say that the board does have broad discretion to address the substance of the comments put forward by the town of Barnstable, with or without their intervention. I mean, they've given us some very specific comments a few days ago that we incorporated many of them into the amendment sheet. Now we have another set. We have to determine how we're going to deal with that. But the board has discretion to deal with that without having to grant the town of Barnstable any kind of intervention. Also, I'd like to clarify, I'm not sure if the town of Barnstable is talking about intervention for a limited purpose or limited participant status, which is a very different thing under our regulations. But either way, neither status needs to be granted as a legal matter in order for us to get to the substance of these comments. Thank you.
Thank you. That's very helpful. Board members, do anyone want to say anything about this?
I'll just say that I'm very interested in the board trying to accommodate the content and substance of the recommendations, which I don't feel like I've had enough time to sufficiently consider. And I do think we can do that without granting the motion either to become a limited participant status, if that's how we're interpreting this, or a motion to be a limited intervener.
just looking at the proposed conditions, it seems like a lot of these items probably can be accommodated within the host community agreement, but it's difficult to know that for sure without getting some response from the applicant as to how much this can be accommodated. I think we need a little bit more time, I think. I agree with I think there's a lot of reasons not to grant the petition to intervene, but I think as Ms. Evans says, I think we have the ability to consider these regardless of the grant of the intervention. We can consider these as comments and proposed additional conditions.
Yeah, I agree. I agree with that. I think we have the authority to do so. I think there are some downsides to granting the motion to intervene at this point, particularly for precedent purposes. This is a very late intervention. We don't want to encourage the idea that even towns can come in at the very last minute and become parties in a case. That being said, I agree with my colleagues here that the substance can be addressed and should be addressed. So what I would suggest, and lawyers can tell me if this is possible, given that we're unlikely to reach a final decision today anyway, given the time that we have left, that the town and the company get together, look at the proposals by the town that have been provided today, see what you can agree on, come back and give us if you can agree on a proposed set of amendments, great. If not, let us know that, and we'll look at the two proposals, or we'll look at this proposal by itself. Is that possible for you to talk together?
I'll answer for the town. Yes, would very much welcome that opportunity. We've had a outstanding relationship with Foley Hoag and would like to continue that. I'm sure that it's the most orderly and efficient way to reach agreement and highlight anything we still have disagreement on. And we'd be very brief in our rehearing at your convenience if there are any items that aren't resolved.
Oh, we're willing to consult with the town. Obviously, we would prefer if the siting board were to make a decision and perhaps direct us to meet and confer regarding the issues raised by the town, rather than postponing the decision to another time in the future.
Fair enough.
But we certainly will meet and confer with the town regardless of whatever the siting board decides.
I mean, certainly meeting with the meeting could result in, changes or to the host agreement or agreement under the host agreement to do certain things. Doesn't necessarily have to be through this order or through this body. I guess what we're asking for is for you to look at the substance and figure out if there's something that you all can do to come to some kind of agreement there.
Well, Park City Wind certainly wouldn't object to a condition requiring us to meet and confer regarding the comments that the town submitted today, or comments of the town. I'm not limiting it to just what they put in today. And with that, I think, if there's not compliance with that, then I'm sure the town will let us know. But I'm confident, as Mr. McLaughlin mentioned, we do have an excellent working relationship, and a close one and a long one. So I'm sure we can talk through all of these issues.
All right, why don't we go ahead and proceed with our deliberation on the rest of the items, and then we can decide at the end where to go from here.
May I offer just one concluding observation? There are a few things I'd be reluctant if it matters to see a vote taken today, because there are a couple of important items. I'm just give you one example. EMF testing, it's proposed for the beach room. We're happy to see that included. That I think is a huge safety issue that needs to be addressed. And frankly, going forward, there's so much concern about EMF and the risks or lack of risks associated with it, that everyone would be well served by testing. And my point being to what Town Manager Ellis mentioned, not only doing testing at the beach, but also for the full length of the cable ashore all the way up to the substation at reasonable intervals. We were suggesting in our draft comments, every half mile or something. With such a critical precedent being set here for these for EMF and the board's comfort and expertise in that score, I think the public would be well served, and the board and the company would be well served, since they're going to be back to you at some point on other matters. Those details be brought forward, just as you have ongoing testing with regard to, we're suggesting not only the length, but annual testing, as you were justifiably concerned about noise testing. I think EMF testing on the much broader scale is vital to public confidence in the decision. Thank you.
Well, yeah, Mr. You have something quick to say?
Just 10 seconds. This is an example of why deciding the conditions at this stage is probably not a useful exercise. I will simply say that the Conservation Commission has ordered additional testing beyond what the siting board has currently required. So as Mr. McLaughlin knows, there is going to be additional testing beyond what the siting board has required. So that issue, I think we have addressed it, but are of course willing to discuss with the town further.
Well, as Ms. Evans noted, the staff has taken into account the town's comments that were submitted on the original TD, and there are several requested revisions to the to the tentative decision that were adopted by the staff specifically regarding the town's request. And this was one of them. All right, I think we should start and we can see where we go from there. So to begin deliberations, we generally have a main motion, and that main motion is generally to have approval of the tentative decision. That opens up our ability to have the discussion on the motion. So would somebody make the motion, please?
So moved.
Do I have a second?
Second.
Thank you. Okay, so I suggest that we'll leave that main motion on the table so that we can have further discussion. And I think maybe what we should do is look at the amendments to the TD first and see if we can sort of get through that part of this. So why don't we, I think that many of these were not substantive, or just more Scrivener errors, etc. So what would you like to discuss first? All right. I am being told this is actually the first time that I'm really doing this at the siting board. So I have been told that we also need a motion now to approve the amendments so that we can talk about the amendments. So could I please have a motion about the amendments, please?
Second.
All right, now we can talk about the amendments. Am I right? Okay, good. The one that I did want to mention was to have a discussion about was the magnetic field condition, and wanted to see what if there are any thoughts on that particular condition, which I believe is the bottom of the first page there. That's on page 87.
Madam Chair, I'm not sure if you're addressing that question to.
No, I'm just bored right now. We're going to deliberate.
Appreciate it. Yeah, thank you. Yep.
So I would like to, I support the language, although the commercial operation, meaning the date when the facility is capable of delivering approximately 800 megawatts feels too late.
That's what I
So
thought.
I would like to see if we could add an interim timing or a series of times. I don't know if we want to say maybe with each 100 megawatts of energy, or if we want to quantify it in a different way, but I think it's going to take too many years to get to this point to be as helpful as I would like it to be. So I don't know if other board members or staff has a proposal to make that a bit more.
Just maybe a point of clarification, in considering earlier milestones before the full 800 megawatts. If we're talking about measuring magnetic fields, which is this particular condition, the amount of current that's flowing through the line is obviously going to correlate directly with the magnetic field levels. So if we're only talking about a project that's reached 100 megawatts out of 800, you're not going to really get an accurate long-term reading of what the maximum magnetic field exposure level is at Craigville Beach. So it might tell you something interesting or useful, and it could certainly be related to the modeling to see if the modeling is matching up well with actual conditions, but it will not give you the maximum magnetic field levels.
I think we get that. I think what we're saying is that you're going to get that when the 800 megawatts come online. So what we're saying is having something before that will give people assurances that the EMF, even at 400 megawatts, for instance, is low. Like what, I mean, what if it came out that it was super high and much higher than was expected? Then there was something could be done in the interim period. I think that's the idea of it.
Right.
Or at least an informational thing that you're not having to wait all the way till, you know, the whole project is built to get some indication of where things are. But I understand your point.
Yeah.
Elizabeth, Commissioner Mahoney, did you have a?
I was just going to suggest to amend or perhaps to layer on an idea that the commissioner mentioned is we know first power can be even less than 100 megawatts. So maybe the first kind of point in time could be at first power. And then we could decide milestones size wise or capacity wise beyond that. But I think given what we've heard, that at first power, it might help to start building the understanding of the impacts.
I support Commissioner Mahoney's amendment to my suggestion. And I do think that there is a lot of public interest in this project. And so while I recognize what Mr. Green has stated, I think it's important to get information filed in the proceedings so that it is known to the public and to the board what's happening at intervals.
So how about first power and 400?
I think it's probably just.
Who's talking?
That's Greg.
Oh, Greg, please go ahead, Greg. Mr. Watson, sorry.
Go ahead. I'm sorry. That was, I was just gonna say, you probably just said, probably with the caveat that these interim measurements are not conclusive in either direction, all right, in terms of what will ultimately be concluded.
Maybe we say for informational purposes.
Yes.
That's a good point. So question for the staff. Do you recommend that we actually try to work out the language right now? You do. Okay. All right. So given the public interest, blah, 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 citing board directs compliance filing. Okay, compliance filing at first.
Energization.
Okay, the energization. And
Did you say 400 megawatts?
I'm just thinking. When the facility is capable of doing 400 megawatts. Okay, so provide a compliance filing, oopsie, for informational purposes, sorry. At energization, and when the facility is capable of producing 400 megawatts and within the first 180 days of commercial operation.
Chair Tepper, can you say that one more time?
Maybe. That's all right. Given the public interest in the potential health and safety risks from magnetic fields, the siting board directs the company to provide a compliance filing for informational purposes at what do you call it?
First
First
energization.
energization. And when the facility is capable of producing 400 megawatts. Period. And within the first 100 days of commercial operation, the siting board directs that within the first 180 days of commercial operation, the company shall demonstrate that the actual magnetic fields, blah, 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 from there.
I support that language.
Do I have a second?
Second.
Okay.
Do you want to vote on each amendment as you're going through and making it? It might be easier than coming back around and
Fair enough, because we won't remember.
what you're
Yeah.
voting on.
Okay.
That would be our usual suggestion
Okay.
is each amendment as you make it, vote
Okay.
on it.
All right. So is there a motion to adopt the revisions to the staff's proposed amendments to the tentative decision on from page 87 of the tentative decision as I just set forward?
So moved.
Second.
Madam Chair.
Sorry, I think we also need to make sure this is the same language in the condition, so it's in it, it's not just page 87.
Correct.
I'm trying to find.
You're exactly right. It's
Page
also
212 would also appear and when the conditions are reiterated on page 12.
Thank you. Thank you. Do you know which condition letter that is, Ms. Evans?
Not off the top of my head,
Yeah.
sorry.
Madam Chair, may I offer something on this?
just a minute, please.
Certainly.
It's a new condition, so it doesn't appear.
Oh,
in the
right,
TD.
that's right.
We would have to add it to the TD.
But it was added in terms of, you were proposing to add it to the TD in your staff amendments.
That's correct. It was in response, I believe, to the town of Barnstable suggestion in their comments from last week.
So both of the staff's proposals with respect to EMF will be modified in this same way.
Yes, so I propose that we modify the language as we just discussed on page 87 and add new condition S with the same language.
Second.
Okay, all in favor?
Aye.
Aye.
Do you do a whole roll call vote because we're?
Yes,
online?
actually, I'm sorry.
I think because
Um,
we're online, we need to do a roll call
We
vote.
do, and give me just one moment.
Madam Chair, if I may, please.
You know, I think we're just going to deliberate right now, so that we can move things along.
Okay, I'm gonna call the roll. Chair Van Nostrand. Aye. Commissioner Rubin,
Aye.
Commissioner Mahini,
Aye.
Commissioner Heibel,
Aye.
General Counsel Costco,
Aye.
Member Bonfilio,
Aye.
and Member Mr. Watson.
Aye.
Okay, the motion
Don't
carries.
get to vote?
Oh, and the chair.
Aye.
Okay, I believe the motion carries unanimously.
So, Commissioner's name is Mahin.
Thank you.
We'll work on it offline.
Yeah, it took me
Practice.
almost a year to do it right, so we'll cut you some slack on that. Okay,
Apologies.
let's move on. So I think, to me, the next issue that we should be talking about with respect to these amendments is the construction hour issue. I think there are a couple of amendments here that have to do with the construction hours. I think the one that appears on page 114. The one that appears
In 82, page 82.
page 82.
Two amendments.
There should be
on
two
page
amendments.
82, which relating to construction hours.
Why don't I have
Let me do that.
Sorry. Okay, yes. Okay, so particularly on the page 82, recognizing that in the document submitted to the board this morning, the town is suggesting deleting that paragraph or that particular statement in its entirety. So I think we have sort of two issues. One is the issue of whether, if the town does not agree to the extension of hours, that the company may come into the siding board. That's one issue. And the other issue, I think, is the time that construction may occur, and the whether the 24-hour issue. So anybody have thoughts on any of that?
I will note that the town's comments this morning make further recommended changes that I think we should consider, at least on page 114. They don't appear to have commented on page 80.
Madam Chair, if I could also invite the board's attention to page 111, section line 8, where we have an extensive commentary on the construction plans.
Okay, I think we should limit our discussion right now to the hours. So let's just take them in order. The first one on page 82 is the insert: work requiring longer continuous duration than normal construction hours allow, such as conduit pull-in operations, is exempted from this requirement.
I would like to amend that language to require advance notice to the town and on a public website to indicate when those exceeded hours will occur. Perhaps 48-hour notice in advance. And I believe we heard earlier in questioning from Avangrid that the company could make that happen.
Could do
advance
48-hour notice.
We did not ask them questions about the amount of time advance notice.
Is it, I'm just from a technical standpoint, will you know 48 hours in advance? I assume that you do. Yes, yes, okay, yes, 48 hours. Okay, so how do you want to word that?
The time pressure is,
I know,
strong.
Yes, it is, indeed.
Commissioner Rubin, there's an existing condition I in the TV that talks about a public outreach plan, and it outlines specifically that the company should notify the public about scheduled start, duration, and hours of construction in particular areas, and the methods of construction that will be used. Perhaps you would want to add to that instead of creating something new.
Do that.
Thank you for that excellent suggestion, Mr. Wong. I think I'm just trying to pair the language on page 82, which is requiring authorization and providing notice. Sorry, I just need a second to.
Yeah, let's just
figure
look at
this out.
let's go back and look at the actual,
Perhaps.
Can I just make a
address the
quick?
Continuous operation first and then separately address the question about requesting additional hours from the town. Might be easier to deal with those separately.
I think there's a great spot to put the language that you were just suggesting, Commissioner Rubin, into the existing condition, which would be such as conduit pulling operations, instead of saying is exempted, shall with 48 hours advance notice and posting on the company website, be exempted from this requirement. Would that capture what you were trying to achieve?
It would, and I would suggest that we also add that language to page 114. I think those two are related.
Yeah, page 114 doesn't have this additional exemption sentence.
so it looks like page 114 says, should the company anticipate the need to extend construction work beyond the above noted hours or days, with the exception of emergency circumstances on a given day necessitating extended hours, the siting board directs the company to seek prior written permission from the town of Barnstable before commencing such work and to provide the siting board with a copy of such permission.
Might I suggest that that's a separate condition? Like you address the 48 hours first, vote on it, and then move that separate requirement might be easier for the board.
That makes sense, although I'm glad you read that because I think we likely should incorporate this exception for emergency circumstances on the continuous work as well. They're accepted from the 48-hour notice requirement in the case of an emergency.
I agree.
Okay, so Ms. Rubin, Commissioner Rubin, read us what you think this now says. Or you want to do it?
Or
Andy,
should
you
I
wanna do it?
read it for you?
Yeah.
Yes, Mr. Green, if you could read that. And we're
Okay,
talking
I'll-
about condition I, correct?
I am referring to page 82, line 7.
Okay.
So the whole insert would be work requiring longer continuous duration than normal construction hours allow, such as conduit pull-in operations, shall, comma, with 48 hours advance notice and posting on the company's website, be exempted from this requirement.
Yes, thank you very much, Mr. Green. I support that language on page 82.
One amendment, before be exempted, I think we should add in case, except in case of emergency circumstances.
Yes. Yes, thank you, Commissioner Heidman.
I think that's might be in there in the original paragraph.
So that is with the hours per day, not this long duration work. The continuous work.
Fair, thank you.
I just wanted to apply equally to
my
both.
point.
This is what you get when you get a bunch of former lawyers workshopping language live. My apologies, but I think it's just clearer if we have it in both places.
Okay, so do we have a motion to accept that particular language with respect to the item that Mr. Green just read on page 82?
So moved.
Second. Mr. Watson can have the second. I just want to involve them.
Yes, can we please do you, I'm sorry, would you want to add something before we vote? Yeah, go ahead.
Thank you for indulging me, Mark Ellis, Town Manager. I observe your deliberation, very thoughtful deliberation of this somewhat small detail. we are available. It merits, this impacts the town of Barnstable, whether it be operating hours or storage of fluid at a site. We need to go through each one of these because this is what we will live with. And we're available. Set a time certain. I'm sure the proponent will sit down and we'll all roll up our sleeves, and therefore you'll have something wonderful ultimately to make a decision on. I'll also say to you though, just to add to this complication of the hours and the emergency issue, I mean, when the weather gets cold and they're doing work, temperature causes emergency, which results in 24 hours. And they don't always know that that weather is going to occur, whether it be a storm or a temperature related. So you can say 48 hours and it'll satisfy what you're writing, but we've just lived it. Again, Vineyard Wind is a wonderful example that we can learn from, do this correctly and safely. It'll take a little time and we're ready to do it. So please.
Appreciate
you.
appreciate the comment. I mean, I would say that the town and the company are always free to agree to additional items that are different than what the siting board has talked about. And I think as long as the items that we're voting on are complied with, the town and the company are free to come up with how the specifics of how they want to do this. And to the extent that there are, modifications that need to happen, if there's a joint motion, we could do that. I think we should try to get through what we can today.
Shall we vote on the motion that was just?
Yes, please.
Okay, I'll call the roll. Commissioner Van Nostrand.
Aye.
Commissioner Rubin.
Aye.
Commissioner
Aye.
Mahoney.
Aye.
Did I get that right?
We'll get there.
Commissioner Heipel.
Aye.
General Counsel Costco.
Yes.
Member Bonfilio.
Yes.
And Member Watson.
Yes.
Okay, the motion carries unanimously. And the chair.
You might have to add it to your roll call list there.
Yeah, it's happening.
Aye, the motion carries. Okay. I'm a little worried on the time. We're at 2 o'clock right now.
There's plenty of food.
Well,
I think
let's,
we can get through the work hours thing maybe next, this, the next
Okay.
one.
let me just do a time check with the board members. Where are you with respect to a hard stop
I have a hard stop
right now?
now.
You have a hard stop. All right. Just looking at when I have a hard stop. Commissioner Rubin, how do you feel about us proceeding without you? For another half hour? Not great.
Let me cancel what I have.
Yeah.
Yeah.
All right. If everybody's willing to go another half hour, I think we can make some progress. Okay, so what are you suggesting we do next?
Any further amendments?
I was gonna try to tackle the work
Oh,
hour
sorry,
thing.
sorry, go
It,
ahead.
it seems like what we have in here on page 82 now is 7 a.m. to 6 p.m. Monday through Friday. And what I was hearing the company say was we'd like 7 a.m. to 7 p.m. Monday through Saturday. And I think what the town is proposing with its revisions, it sort of looks like, is it just notice to the town? Because I think what the amendment is that the way staff had proposed it is that the company has to request prior authorization from the siting board and shall provide the town of Barnstable with a copy of any such request and authorization, which seems to me the town would potentially have an opportunity to object to changing those extended construction hours or days. Am I reading that correctly, Ms. Evans? Randy?
Yes.
Yeah, the point being is the company and the town should be in discussion first.
Correct.
And this provision would only kick in if those two parties were not able to agree on hours and the company felt that they really need to put that to this and involve the setting.
And if I'm understanding, the town's proposed revisions is just to take that ability to come to the siting board out of there. The amendment that the staff had proposed.
That's correct.
Yes, that's what they
I
found
guess-
this morning, yes.
I would move that we would adopt the amendment as staff proposed. And in my mind, as long as the town of Barnstable has an opportunity to get a copy of any such request and authorization, it does need to be approved by the siting board. And that would provide an opportunity. I understand there's not support for going 7 to 7 Monday through Saturday, but that could come back to the board. I think that what staff has proposed is an acceptable way of dealing with that.
I guess my view is that we should keep the hours of 7 to 6. And allow that language here as written.
Correct. I'm not
Is that what you're-
proposing,
is
yeah, I'm
that
not
what you're
proposing to
proposing?
change the 7 to 6, but
Okay.
just acknowledging we know there's gonna be some disagreement about what those normal construction hours should be, but the process should be, they need to come to us with copy of notice to the town of Barnstable.
That seems reasonable to me. So do we do
So
not need to do any
No,
amendment then?
I think that
You
as
think
it's
that
written is
covers?
fine. I would.
Sorry,
Madam Chair, may I be heard, please, respectfully?
sure.
Thank you, I appreciate it. It's obvious from our earlier discussion that it seems unlikely that intervention status would be granted, but it was also on the condition that we would have a chance to weigh in on our requests for either commentary on what's under debate and or weighing in on new matters or additions and modifications, edits that we are proposing. It just, again, looking at the hour, we're going to be in a rush already to wrap this up. I don't see a meaningful opportunity for exchange and comment. I would respectfully urge us to put the matter over for a week or two. We will be here at your convenience and give us a chance to work with the Foley Hoag group and see if we can't come to a resolution. A lot of these and take them right off the table, quite frankly, so that when you do meet again, it will be most expeditious. But I am not sure we're feeling that we have a seat in this discussion right now. So.
All right, I'd like to hear from the board on your views on seeing how far we can get today. Or do you think, see how far we can get today and then vote today? Or provide some additional time for the town and the company to try to come back with some agreements on these conditions?
I'm inclined to give the parties more time to confer, provided they can do so expeditiously. It sounds like both sides are willing to do so. I think it would allow us to move through our proceedings more efficiently. And it sounds like there are other Conservation Commission and other approvals that actually already address some of these proposals to council's earlier point. So if those can be dealt with quickly and by reference to another document, that would be helpful as well.
I'm in agreement with Commissioner Heupel.
Yes, I agree. As I mentioned before, I think a lot of these things can be handled through the host community agreement, but I would be interested to see what the applicant's response is on this PFAS proposed conditions. So I think giving the parties some additional time to try to work that out and bring it back to us would be beneficial.
How much time do we feel? What time frame?
Is it possible, if the parties actually could agree that we could do something without another meeting? Or do we have to have a meeting? I'm worried about time, getting everybody's schedule. You know, it's not easy to just say we're going to do another hearing. So I'm wondering, I think we probably have to have a hearing on it, don't you think? I mean, we can't, even if they agree. I still think we probably need to vote on it and.
Well, I think that the discussion about what could be entertained within the context of the host community agreement is the potential opportunity for the board to still get to a yes vote or a no vote today, whatever the vote is. And and perhaps provide some directive or another condition for the company and the town to continue consultative discussions around the most recent comments by the town to see what can be achieved in modifications of the host community agreement. And that does not have to require a board approval. That is an option.
Mr. Kimball.
Look, we want the chance to talk to the town about the matters that were raised. Again, we do really wish they had raised them weeks ago, or at least last week, and given us a chance. So this is unfortunate. The timing is unfortunate, and I haven't heard a good reason for why. However, we would be fine to sit down with the town. We would request that you issue an affirmative vote today if you can get through the issues on your plate, with a condition that within 5 days, we sit down with the town. We confer about all the issues they've raised, and we jointly submit some kind of compliance report saying what we've agreed on, and you then have the opportunity to incorporate the agreed upon ones right into the decision. And if there are any in dispute, then you have the opportunity to look at those. I have a feeling there won't be any in dispute, and we'll just be able to submit a clean kind of compliance filing. But we're nervous, frankly, about giving people schedules. It's almost the Christmas break. It sounds to me like if a vote doesn't happen today, it's probably January or beyond. And this has been going on a long time, and I don't think you should sort of penalize the disposition of this because the town chose to issue comments very late in the process. I can assure you, we have a long-term relationship with the town. We have every reason to get to yes, but we really don't want to hold up a vote on the decision for what could be months or more to go over what I think are important issues to the town, but very resolvable ones.
I mean, my concern about that, Mr. Kimmel, is that if we agree on certain conditions in the way that they're written today, and then the parties come back with, additional information, we're still going to have to get together.
Well,
and we don't want to limit your ability to have a conversation by us, sort of shaping that.
I guess what I had in mind is the town and the applicant would submit some kind of filing that indicates we are in agreement on these things and we would like them to be added to the decision. And it would be a consensual filing. I don't think it requires a new hearing or anything on that matter. That's how we think this could expeditiously and efficiently be resolved. And you might want to put a timetable on us to get that to you so that it moves quickly.
So let me ask the board this. If we voted today on the tentative decision, but not the conditions, in other words, can we vote to say that we are going to approve the project subject to an agreement on the conditions? Go ahead, Ms. Evans.
May I offer just another mechanism for your consideration?
That would be helpful.
If you're going to vote on the tenant decision today, it should be inclusive of whatever conditions that you're going to include. If the parties wanted to change the conditions of the final decision, there's a provision already in the final decision that says they can file for project change. They could file, and we treat project changes depending on the nature of the change. Sometimes it's a staff approval of a project change. Sometimes it's a board approval. It depends on the nature of the project change. But if they wanted to change the final decision, they really need to file a project change under the rules that are already in the decision.
Would we have to amend our final decision if we wanted those agreed upon conditions to be conditions of the decision?
If you wanted them to go actually into the decision, yes. Yes. So you could just simply put a condition in here that says that the parties will go out and deal with these conditions and could file a compliance filing. The compliance filing would go into the docket, but it wouldn't go into the actual decision itself because you had already voted the decision and a final decision were already issued.
If it's done as a project change subject to staff approval, if approved, is that enforceable?
Yes,
In the same way that a condition of the final decision would be?
yes, yes.
Okay.
I think you can't do it part way.
Yeah.
You need to either vote or not vote. That would be the choice. And if you're going to vote, you should consider whether you're going to add in the staff amendments as you've changed them already into the decision. And if the parties agree that there are some differences after the decision is done, they would file a project change with us.
Is it possible to create a presumption that these issues can be dealt with in the host community agreement? When I look at the construction sequencing thing that Mr. Ells referred to earlier, then we have some additional language about the hazardous products and containment. Seems like these things belong in a host community agreement. Is there a possibility to approve the amendments as staff has proposed them, and then create a vehicle for if that doesn't get worked out in the host community agreement for that to come back?
So that would be a decision of the parties. That the board doesn't approve the host community agreement. It's a separate contract between the town and the company. They would decide whether or not to include items in the host community agreement. If they wanted to include it for the board, they'd have to file a project change with the board. We are not going to order them to put it into the host community agreement. That's their own separate agreement.
But we could have a condition that says that they have to meet and discuss, the items that have been raised.
And report back.
And report back, exactly, thank you. We could have a condition that says they need to meet and discuss those items and report back to the board in X amount of time.
Okay, I think this partially depends on sort of how far we can get today. So let's keep going on what our proposed changes would be, and see where we are in 20 minutes. So one of the other changes that I wanted to talk about was sort of this definition of work. I do think I take the town's concern that everyone's like hanging out and not necessarily being quiet and driving their big trucks in at 6 o'clock, just all waiting for 7 to come. But the problem is that they still will. It would just mean less time for them to work if we say, well, you actually can't come to the site until 7. So wanted to get people's thoughts on that.
In my mind, that breaks it up into staging versus work. And I think what I'm hearing from the town is that the staging should occur during work hours. But to your point, Sharon, if we don't want to go into longer hours, it's a self-fulfilling prophecy at this point. It just is very circular. But I'm wondering if there's an opportunity to limit staging hours. And I don't know if there's been examples of that in other agreements or other decisions, but that there's a limitation about the staging hours to just a half an hour before the start of work time.
Mm-hmm.
And obviously, all employees have to abide by the Commonwealth's laws, which include no idling longer than 5 minutes. Chapter 90, section 16A. Thank you.
Yeah. So the idea would be to say, well, let's find the actual wording. Where is the wording?
Page 82, right? So we're still talking about
Yeah, right.
7 a.m. to 6 p.m.
Okay, so
So Commissioner Mahoney, my understanding, you're proposing maybe allow there be a staging time preceding 7 a.m., but not longer than 30 minutes?
I think that would be reasonable.
Mr. L.
Half hour seems a long time to me.
6:45.
6:45.
6:45.
I
15-minute staging time.
suggest a half hour because people get to work at different times.
Well, construction starts at 7.
True, fair.
I just want to comment, if I may, that, you know, a lot of construction workers are coming from great distances, and traffic is always a huge variable.
That's what I was.
So if you time it so that you're just in time, you're going to be late. And if you're late, the project doesn't get started. So I think there's a need for people to arrive well before the work is to begin, not just for staging, but also just simply arriving at the job site and being able to work when the clock strikes 7.
One could argue that we are asking certain neighborhoods to bear this equipment for a long period of time, and that perhaps people could corral in a different place. So not all of the emphasis is on one geographic location to address those concerns about traffic. But I recognize there's local traffic as well. So I'm not offering anything helpful other than to say that this is complicated and staging is difficult.
Quick, very quick. Just stay where you are. Just tell us now.
It is complicated, and it's more complicated because it's in a residential and not an industrial zone. So to get to a meaningful answer on every single one of these, it's gonna take time to get to a point where you can make a good decision.
Right, and you all are going to have the opportunity to do that.
But we want you to as well.
Well, we will have the opportunity to look at what you've done. So I feel confident that we'll have the opportunity to, yes, go ahead.
I'm sorry, I'm just rereading this paragraph on page 82. Should the company, I mean, again, I think there should be maybe some recognition of staging time. But it says right in here that should the company need to extend construction work, they go to the town, and then if that doesn't work out, they come to us. So I think there is a process in there that hopefully is guiding for the town, but I also think it would be helpful for us to have some sort of concept of staging in here in recognition of that need to get things ready before 7 a.m.
Okay, so let's do that. In line with the setting board. All right, so we can just add you can add an additional sentence that says staging shall not occur any earlier than
Any staging or congregation.
any staging or congregation of the workforce shall not occur before
On site.
6:45 or
On
before 6:30.
On site. Because
On site,
we're not
yes,
banning
good.
them.
Yeah. Yes. Shall not occur before 6:30.
Can we also add any vehicles must comply with the state anti-idling law?
That's company has made.
Since they have to.
You don't have to,
Anyway.
you don't have to commit.
They
You
have
can
to
just
do it.
enforce.
The company has committed.
Yeah.
Great.
Well, I think it's the town police force that enforces.
Correct.
But you would like to add it, just.
I would like to add it to be clear in this section.
Okay. So what is the sentence?
All vehicles on site need to comply with state anti-idling laws.
All right. Do we have a motion to adopt the language with respect to the timing and the staging?
So moved.
Second.
Can you do roll call? please?
Yes, and I will count you this time. Apologize. Chair Van Nostrand.
Aye.
Commissioner Rubin.
Aye.
Commissioner Mahoney.
Aye.
Commissioner Heipel.
Aye.
General Counsel Casco,
Yes.
Member Bonfilio,
Yes.
Member Watson,
Aye.
and Chair Tepper.
Aye.
Motion carries.
I think we should take up the noise, no? No, I think we should take up the noise issue next. Which is condition. Which is condition R. Yeah, I feel like the staff's proposal is additional amendment is pretty thorough. When you read them together, the first paragraph. In addition. I'm a little bit concerned about the, when the relevant information from the equipment supplier is made available. I'm just not sure when in the process that actually is going to be. And my guess is that the company doesn't know when you'll have the information with respect to, the equipment and the noise level of the equipment.
We will take a pre-construction plan, so we know we will be telling you after construction started.
Signing board further directs the company to provide a sorry, I'm just reading from the staff's proposed revised condition R. In addition, to gain earlier visibility of the steps being taken by the company to achieve this result, the siting board further directs the company to provide a pre-construction compliance filing documenting the noise profile of the onshore substation equipment, then listed, when the relevant information from the equipment supplier is made available. So I guess I'm just confused about that in the sense that you're saying that you're providing a pre-construction compliance filing. Then what does that phrase mean when made available?
So is that the point that you know that the manufacturer has been able to produce equipment that complies with the standards?
It may indeed happen at the time you know that the equipment providers are meeting the standards, but because this equipment will be custom designed and custom engineered, even after it's procured, there may be back and forth on the design and engineering that may improve the sound profile. So exactly when the precise sound information that the vendor may ultimately provide becomes available isn't 100% certain right now. And obviously the company can't provide, if that's what you're seeking, provide that before it's available.
But the idea is that you will not commence construction without providing that information to the board.
Correct. That information will be filed as part of a pre-construction. There would not be construction before.
It's just good to be able to see you.
Okay. Fair enough. Yeah, I think that's what that says too. Does anybody have additional thoughts on this condition R?
I do like the staff language, and I note that there's a proposal to replace the language you just wrote with this subsequent sentence that you did not read into the record. I do think it's important for the board to direct the company to speak with Intervenor Johnson to make clear to her this information and to try to get to consensus about the additional noise mitigation measures if needed. So I propose to add that language that I will try to write out now.
Can I just offer one observation, which is when a compliance filing comes in, it is made part of the official docket. So any parties, as well as public residents, would be able to see what the compliance filing included and be given time to comment, so that while the board is reviewing that information, we would know what comments there were perhaps from Ms. Johnson's counsel or other abutters in the vicinity of the substation to voice any concerns about what the compliance filing includes.
I think it would be good to have notifications specifically, you know, to the butters.
First of all, there is, not only is the information put in the docket, but it is sent directly to the parties. So Ms. Johnson wouldn't have to look for the information in the docket. It would be provided directly to her at the time any of the compliance filings are made by the company.
But Commissioner Rubin, you were hoping that there would be a conversation that would happen.
Correct.
Yeah.
So I propose to add to the end. So following the replacement sentence where it ends with that the company intends to take as a result, I propose to add, as part of this process, the company shall communicate with Jacqueline Johnson about additional noise mitigation measures and attempt to reach consensus.
I think that's a reasonable addition.
Okay. Do we have a motion on adding Commissioner Rubin's sentence to the end of condition R?
So moved.
Second. Did you say yes? Who said yes? Who seconded?
I thought you did.
I thought you just.
Oh, I can't.
Second.
Thank you. Let me do a roll call vote.
Yes, Chair Van Nostrand.
Aye.
Commissioner Rubin,
Aye.
Commissioner Mahoney,
Aye.
Commissioner Heipel,
Aye.
General Counsel Costco. I think I heard an aye.
Yep.
Member Bonfilio.
Aye.
And Member Watson
Aye.
and Chair Tepper.
Aye.
Motion carries unanimously.
May I note that where some of this language appears more than once in the TD, it appears a condition, but it also appears earlier in the substantive section. We will make sure that the final decision is consistent in both places without us having to figure out where all those pages are as we sit here.
That would,
But the staff will take care of that, and we'll just note that we're going to do that.
that would be helpful.
No.
On condition P, the foam. I thought that the staff's addition made sense, but wanted to. My understanding is that the purpose of the staff addition is that they may not use foam. So it sounds like to me that the end result of this is that if they use foam, then they cannot use a foam that employs PFAS. And if they do not use foam, it doesn't matter.
Agreed.
Madam Chair, may I be heard, please?
Yes.
Thank you. Our observation on that is that we'd be thrilled with that condition, but it begs the question with emerging contaminants and all the like that continue to haunt us. So many examples in town that we've suggested in the draft edits that there be a required professional certification that whatever is going to get substituted and stored on site is in fact compatible with environmental and water quality conditions. We don't want to find out that the product sitting there is suddenly a real problem if it's engulfed in a fire or something that and turns chemically to something we didn't anticipate. We'd like that type of professional review of what's going to be stored on site.
Secretary, may I know that there is a condition that relates to the emergency response plan and the things that are to go into the emergency response plan? Perhaps this detail about firefighting might be an amendment to that condition. That's condition O.
I do invite the board's attention to some extensive draft language that we've included on emergency services and operations and response plans that get into some of those details. Given the hour, is it appropriate to suggest that we, having accomplished something today, that we, a lot today actually, that we be given the opportunity to sit with Foley Hoag and see if we can complete this process and come back to you? There may be very little left on the table for debate, and if there is something that is debatable that needs your direction on, then we could drastically limit the allocation of time for another meeting. But I'd respectfully suggest that might be productive.
I think we're quite close, at least on this one, so I'd suggest we at least proceed through. And to Councilor Evans's point, I think that is a helpful vehicle. The report, or excuse me, the plan that's contemplated in condition O would suggest adding to condition P that the company will provide safety data sheet or other demonstration that any expansion foams stored at the site do not contain PFAS. I think that will provide the town with the information that it's looking for without, requiring retention of new experts and what have you.
All right.
May I just respond that, we didn't know PFAS was a problem until it became a problem, and that's what we're trying to avoid this time around as well.
Understood.
Thank you.
Okay, do we have a motion to adopt Commissioner Heupel's amendment?
So moved.
Seconded.
We have a roll call vote, please.
Yes, Chair Van Nostrand.
Aye.
Commissioner Rubin,
Hi.
Commissioner Mahoney,
Aye.
Commissioner Heupel,
Hi.
General Counsel Tosco,
Yes.
Member Bonfilio,
Yes.
Member Watson,
Aye.
motion, and Chair Tepper.
Aye.
Motion carries.
So I did want to talk a little bit about the dielectric fuel issue. I'll note that we heard from several people today that it was raised for the first time on Friday, and I did spend some time with the record this weekend, and that's not true. The issue has been raised in the past. That number has been said in the past in the I think it was in the FEIR, maybe the DEIR. So I don't think that this is a new finding that just came up for the first time. That being said, it seems like a lot of people were surprised about it nonetheless. And so my hearing of what we talked about today is that this amount of dielectric fuel is not unusual, and that there has been specific agreements between the town and the company about containment and specific containment for this particular substation that's aggressive. But I wanted to hear what others have to say about that issue.
No, I agree, Secretary Tepper. I think Mr. Wang went through a pretty good detail. You have you have 110% of the containment as well, and the additional redundancies. I mean, I do think this has been addressed. I appreciate that additional explanation being added by including it in the document. I don't believe this is a surprise. I'm satisfied that the dielectric fluid is dealt with in a responsible manner.
Anybody else?
I agree. I think the proposed amended language from staff does address the issue. I would like to direct that the company do some sort of public education about the facility as a whole that includes the dielectric fluid issue.
So I think that's a great idea. So how do we do that?
I have to find it, but there is a public outreach condition.
Currently condition I.
Thank you.
Look at the back end of your CD.
So, Madam Chair, I would note that I is very helpful about focusing in on really a lot about the construction and some related matters. I think maybe it just needs a simple addition about just information about the project in general, including information about these fluids. But I haven't written it yet.
Okay. How about the comprehensive outreach plan, public outreach plan shall also include
general public education on the use, construction, and maintenance of electric substations.
Yeah, I like that.
The use, what was your second term?
Construction and maintenance.
Use, construction, operation, and maintenance.
Yeah, operation and maintenance. Yes, thank you.
And that will specifically include, because it says at the beginning of the condition that will be in consultation with the town. So that's. All right. Are there other issues that we heard?
We do need to do a motion on.
Oh, sorry. I'm sorry. Yes.
And before we get to a motion, do we need to have any sort of reference to the fluid, or is that what we just captured enough?
I mean, to me, it captures it.
It does
I
to me,
mean,
it just
we
like-
certainly can say that the intent of the board is that it will include a discussion with respect to the dialectic.
Okay.
Fluid.
Yeah, that's why I keep saying fluid.
I know, I keep saying, you
Can't say
it's fluid. Okay. Okay, so can we have a motion, please?
So moved.
Seconded.
Roll call vote, please.
Chair Van Nostrand. Aye. Commissioner Rubin.
Hi.
Commissioner Mahoney.
Aye.
Commissioner Heupel.
Aye.
General Counsel Costco.
Yes.
Member Bonfilio.
Yes.
Member Watson.
Aye.
Chair Tepper.
Aye.
Motion carries.
So, looking at the public comment from public comments that we have received from the public and from the heard today. Are there other issues that we would like to discuss?
Madam Chair, we're losing audio again.
Audio.
I mean, I guess what I would encourage is that we have the condition that requires the town and the company to review the conditions and discuss them. I'm not coming up with the exact language, just my idea right now. And that in those conversations, the concerns that were raised by the public today and in the letters that we received be part of that discussion. Mr. McLaughlin.
Thank you. With respect to the containment issues, I wanted you to know that after the Vineyard Wind's approval by the board, we convened subsequently and created a memorandum of understanding with regard to containment and a whole series of more specific items that I think would be worthy of your consideration. And so that, if I may recommend, when we do provide a compliance filing, which I think is still in order here and would recommend it, that we include the details and perhaps refined details of that memorandum on governing the Vineyard Wind matter to you for consideration. This is a
Mr. McLaughlin, I think you're free to have any kind of conversation you all want about this issue and bring it back to us if you have an agreement.
I appreciate it. Thank you.
So, Ms. Evans, the motion the provision that you were suggesting with respect to the compliance filing, can you give us a sense of how you think that should work, what we should say?
Let me give it a shot here.
Yeah.
Thank you. The siting board directs the company to meet with the town, meet expeditiously with the town to discuss the town's recommended conditions and to report back to the board. The question is, do you want a date certain?
Yes.
By the end of the year? Report back to the board by the end of the year?
Seems.
How about by January 5th?
And report back to the board by January 5th, 2024.
Mr. McLaughlin, does that work for you?
That does. I would be pleased to respond, and we will put every effort, if that works for Folio Egg, that's fine with us. We'll make it happen.
Thank you. Okay.
Alan, could you read back the condition that I just stated, please?
Siting board directs the company to meet expeditiously with the town to discuss the town's recommended conditions and to report back to the board by January 5th.
2024. Thank you.
And would that require the board to reconvene?
The way that is worded, that's just a report from the town and the company. If the company wishes to change the decision in any way, the company already has the obligation to file a project change with the board. So right now, the way I've worded it, it would just be a report back to the board. If you'd like to add more to that,
No.
you can do so. It really depends on what they report back, right? Whether there's agreement or disagreement and the nature of what they report back.
A modification of the host community agreement would be a mechanism to incorporate an understanding if there is one that comes out of that discussion without requiring further action on the part of the board.
What if they cannot agree?
Then the board can investigate a compliance filing. It has that authority and can conduct proceedings or issue discovery. And
So are you calling this a compliance filing? What are you calling this?
I would call it a compliance filing.
Yes.
That will allow the town to respond to any concerns that the town still has in the compliance filing after the discussion.
And if there's more than if there's a modification of what the board has already decided, then there's a mechanism to address that modification.
But what if, sorry, but what if, so the town, what would be the mechanism for the town filing something that they did not, if they did not agree?
When the report is filed by the company, because that's who we have the authority to order to do
Right.
something. That compliance filing will go to all the parties and we can ask that the company make sure that that compliance filing also goes to the town. We can provide the town an opportunity to respond to that compliance filing if there are still areas of disagreement.
That would be good.
So I can amend what I just said. The company shall provide the town with a copy of the report also by January 5th, 2024, for the town's consideration. For the board's consideration, excuse me.
Okay. Okay, do we have a motion for that?
So moved.
Second.
Call the roll. Chair Van Nostrand. Aye. Commissioner Rubin.
Aye.
Commissioner Mahoney.
Aye.
Commissioner Heipel.
Aye.
General Counsel Costco. Member Bonfilio.
Aye.
Member Watson.
Aye.
Chair Tepper.
Aye.
Motion carries.
Okay, so is there any other issues that board members would like to discuss now?
My one suggestion is that we heard during comments today about adding the condition from the local order of conditions regarding the magnetic field monitoring. I think, I don't have it at the top of my fingers, but I wonder if we could add that to the decision. One of the conditions. And I'm hopeful that staff can help find that language.
The language is not in, the language is in the order of conditions that was filed with the planning board. So that language exists. It's a complicated provision. It's a complicated provision. And I would just respectfully suggest that the condition is enforceable by the Conservation Commission, and we're committed to complying with that condition so that it may not need to be a requirement of the siting board.
That condition would be part of the record, but it is not reiterated in the tentative decision.
And if I could observe the one of the issues there that we're dealing with is that the Conservation Commission's limited jurisdiction geographically it does not extend remotely as far as we would like to see it extend here, i.e. the full length of the cables plus the substation. So while it's a start and there's some good guidelines in there, frankly, we as council weren't particularly happy with the limited time of compliance testing for EMF, but also the geographic limits of that really don't address the concerns we're raising here. Thank you.
So I would suggest that in the provision that we just passed, this would be the kind of thing that could be discussed during conversations.
We'd agree with that and be content with that resolution.
So I don't think we need a additional motion or additional amendment.
May I also just to remind the board, if we go back to the voting on the amendment sheet as previously amended, here presiding officer Shea did note that there was a footnote that was missed. Some edits on a footnote was missed. We want to state that we're assuming that the amendment sheet includes that footnote. So when it is voted upon, that's also included.
And the fix of the duck.
Yeah, the duck bank.
Yes.
That has already fixed.
Okay, so I think the decision of the board, the proposal by the staff amendments include a decision on the motion to interview. So I don't think we need to do anything more there. I think on the motion that was raised this morning, the staff could rule on that motion, have the authority to do that, or we could vote on that now.
I would prefer that the board vote on that now, which is an amended motion for limited intervention by the town.
So do we want to, does somebody want to make a motion on that?
Sorry, do we need to clean up the amendments first? Don't we need to vote to approve the entire
The
amendment
amendment
sheet?
sheet does have the ruling on the first petition. The
But
late
it has a,
petition
no,
and
but Commissioner Heupel's right. Since that motion is included in the amendments, we should probably vote on the amendments and then do a separate thing on the new motion.
we could do it that way, absolutely.
Okay, so we have a motion on the table to adopt the amendments of the staff to the tentative decision. So I think now we need a motion to
I'll try it. I'll move to amend the proposed staff, move to approve the proposed staff amendments as amended on the record today with the addition of the missed footnote and the correction of the duct to duct comment that was raised by a commenter earlier.
Second.
Second. Okay, Chair Van Nostrand.
Aye.
Commissioner Rubin.
Aye.
Commissioner Mahoney.
Aye.
Commissioner Heupel.
Aye.
General Counsel Costco.
Aye.
Member Bonfilio.
Aye.
Member Watson.
Aye.
Chair Tepper.
Aye.
Motion carries.
Okay, so let's do the motion for the intervention.
I guess is the question, do we approve the amended motion?
So, my view is that we are addressing the substance of what the town asked us to do. In the first letter, there were many changes to the amendments that the staff did to address those concerns. The other concerns that were raised this morning are being addressed through this new condition. My view is that there isn't the need right now to have a party because we're going to address substantively the issues that they have raised.
I concur, and as was noted earlier, I'm concerned if we did grant it with precedent and how this would impact future cases, so that's also guiding me.
I concur.
Okay, so we need a motion to deny the,
Motion to deny the town's amended petition to serve as a limited intervener.
Seconded.
Chair Van Nostrand.
Aye.
Commissioner Rubin.
Aye.
Commissioner Mahoney.
Aye.
Commissioner Heipel.
Aye.
General Counsel Costco.
Aye.
Member Bonfilio. Member Watson.
Aye.
Chair Tepper.
aye.
Motion carries.
Okay, so now we need I think, motion, we have the
We have the
underlying motion on the table to adopt the tentative decision
with the amendment.
with the amendments as we just voted on. Staff amendments amended by us today. All right, can you make the motion?
I move that we accept the order with amendments as amended and voted on. Is that right?
Decision.
Decision, thank you. I live in a
Second?
deep.
Second.
Okay, here we go. Chair Van Nostrand.
Aye.
Commissioner Rubin.
Aye.
Commissioner Mahoney.
Aye.
Commissioner Heipel.
Aye.
General Counsel Costco.
Aye.
Member Bonfilio. Member Watson.
Aye.
Chair Tepper.
Aye.
Motion carries.
We have a motion to adjourn.
So moved.
Second.
Third. I'm gonna take a roll call. Sorry, folks.
Go ahead.
Chair Van Nostrand.
Aye.
Commissioner Rubin.
Aye.
Commissioner Mahoney.
Aye.
Commissioner Heipel.
Aye.
General Counsel Costco.
Aye.
Member Bonfilio. Member Watson.
Aye.
Chair Tepper.
Aye, and just with a note that really requests that the company listen to the town and the community about their additional concerns and work those out in a collaborative manner. Thank you. Right. Appreciate it. All right,
Meeting is adjourned.
meeting is adjourned.
Off the record.
Off the record, please.
Thank you.
I've got some emergency things.
Right, yeah, wrong.
No, not okay.
That okay?
Andy,
Please.
Andy, can you end the?
Yeah.
It's probably-